We are rolling whenever you're ready.
All right, cool. Hello everyone, my name is Joe Malone. I'm the founder and the CEO of Southern Cross. I have here with me today Mr. Dan Collins. He is a defense attorney here in the state of Illinois who specializes in firearms use and the use of firearms in self-defense. Tonight's episode is going to be titled To Kill or to Be Killed, a deep dive into the legislation and scenarios within the state of Illinois on what you should or should not do when carrying a concealed firearm. We're also going to dive a little bit into what to expect when you possibly have to use a firearm in self-defense engagement. Dan, thank you very much for joining us.
It's nice to be here tonight. I look forward to talking through these issues.
Yeah, me as well. We've already had a pretty good conversation going off camera. Dan and I have never met before. We spoke briefly over the phone a couple of times, but he was very kind and benevolent in giving us his time and his effort and his energy and going into a lot of the surrounding circumstances and the context for people when they use a firearm here in the state of Illinois. And you have quite a bit of experience in this realm as well, don't you?
I have. I've done a lot of trials on the issue. I have taken. I've asserted self-defense with the use of firearms in a murder case. I've done a numerous reckless discharge of firearm cases. Firearms have been an area where I've done a lot of trial work. Too many trials to count. Also, since concealed carry came into law in 2014 in Illinois, I've been right on top of the laws and doing appeals for those who've been denied their license, and for cases involving DUIs with concealed carry license. And other issues with concealed carry license.
Awesome, that's great. Thank you very much again for agreeing to meet with me and to give me your time. And most definitely I appreciate the candidness. We're going to have a great conversation tonight. We're going to give users out there in Illinois and the rest of America, but again, we're staying specific to the state of Illinois here, okay? So don't get confused if you live in another state. But we're going to give really raw and uncut information out there to all of you so you can hopefully use it. If you have any questions or comments or want to reach out, please reach out to myself or Dan at any point in time, probably myself, and then maybe I could let you know about it so you're not getting too blown up. But most definitely reach out if you guys have any questions or comments. Just to start, let's kind of just dive into the Illinois concealed carry law. So you've been practicing law for 24 years, is that correct?
That is correct.
And Illinois concealed carry legislation came out in 2014, if I'm not mistaken.
That is correct. Prior to that, there was no concealed carry in Illinois. Illinois has been an interesting state. We have had some of the most prohibitive laws in the nation in regard to concealed carry, and they were just so anti-concealed carry, and a lot of that came from Cook County itself. The city of Chicago wanted nothing to do and vehemently fought and lobbied against the right to concealed carry. The right to concealed carry was won in the courts for the state of Illinois, and the state of Illinois was grudgingly dragged to the point of granting the right to concealed carry for concealed carry holders in Illinois. And that right was finally won, and we were granted that right in 2014.
I work a lot of different places with people from all over the world, and specifically in America, when people know that I am from Chicago and live in Chicago, and then I tell them I'm a concealed carry instructor, they look at me cross-eyed. They say, I thought you couldn't own guns in Chicago. Do you still run into people like that yourself?
Oh yes, again, Chicago has a reputation worldwide
for
those old days when we were an absolute no-carry state. So we did have that reputation around the world for that for a no-carry state, and Chicago was the focal point for that no-carry city. So yes.
So when the law was originally passed, and you were kind of reviewing the law, what were some things that you were looking for, and what were some things that really stood out to you for eligibility and disqualifying criteria, and in carrying in general?
In carrying in general, I think the things that I was really most interested in when it first passed was the prohibited areas. I think that the biggest prohibited area that stood out to me was the public transportation area. Because I thought, I think that might go back to Bernie Gates and the New York subway vigilante case. I don't know if you remember that case back in New York. That's a long, long time ago.
We're talking the 80s?
Back in the 80s, maybe 1978. So it was a long time ago. But I've always felt that one of the areas where a person perhaps had the most felt, again, we always go back to the fundamental aspect of the right to conceal carry is the right to self-defense and the right to defend yourself.
Mm-hmm.
And I think that right most certainly is perhaps most fundamentally necessary is perhaps on public transportation. We know that some horrific assaults and batteries occur on public transportation, but it's also one of the prohibited areas that you can't carry on as public transportation.
So, for example, in Chicago, the CTA train.
Yep, the CTA train. If you were to go from anywhere on the CTA train, you can't carry on the CTA train.
And as you were saying, we know that a lot of crime takes place every single day. I would say roughly, there's at least one battery that is being called in on the CTA lines, or at least from the reports that I see, open source, nothing too specific. Did you hear about what took place in, I think it was New York or Philadelphia last month, where the woman was sexually assaulted?
Yes.
Would you go ahead and please describe for the audience a little bit of what was taking place there, and then what your thoughts and opinions are on all of that?
Where there was an open sexual assault that was caught on camera, where there were bystanders who actually cheered on the sexual assault, if I'm correct.
See, I didn't even hear that they had cheered it on.
I heard that it was actually filmed by bystanders, and it was actually cheered on.
Wow.
So I heard that was actually what occurred.
And nobody ended up even calling 911.
Nobody called 911, and nobody even stepped in to stop the sexual assault.
And in a situation like that taking place here in Chicago, now I myself would most certainly put myself in harm's way in that regard, because I don't think any human should ever have that done to them by any means. However, to your point, we know that a lot of these crimes are taking place here on the public transportation lines or in those routes or those facilities, and yet in Illinois they say you can't carry a concealed firearm within them. Why do you think that is?
And that's again, I sat and that's what I did in 2014. Is I was like, why would you make the L lines, where we know it's one of the most troubling areas, a prohibited area of carry? And the logic defies me. The only thing I could think of is to prevent. There seems to be no logic to it. Do they feel that there's going to be escalated violence because of the presence of firearms on a public transit system? That would be the only thing that would seem to make sense, is an escalation of violence due to the presence of firearms. They would seem to at least be able to have some statistical evidence to support that. And I don't think there would be. I don't think there would be any. There should be a study to support that as well, but I haven't seen anything. I'm not aware of any evidence like that to support anything like that.
Interesting. So, when the law was passed, that stood out to you, and I definitely want to talk about prohibited places here in a moment, because you need to know where and where you cannot go with a concealed firearm, even if you're licensed, because you will be held accountable, as we will talk in a little bit. But let's also talk about the state's requirement for the length and duration and the amount of training that somebody receives. So in Illinois, it's only 16 hours. To myself, a trained firearms expert, spent my entire adult life dealing with firearms. That is basically nothing. However, if I'm not mistaken, Illinois has the strictest time requirements in the entire country.
That is correct. You are correct. And let's take one step back before we go. And let's first off, before we go to training, let's make sure we're clarifying what the definition of concealed carry allows you to do. Okay.
Okay. Yeah.
A definition: a person allows a person to carry a concealed firearm on or about their person, and allows them to carry within the passenger compartment of the vehicle. So just so we know what the concealed carry license allows them to do within the state of Illinois.
Okay.
We're now into the training. What's required to get them to that position to carry? Okay. And yes, Illinois does have the most strict in the country. So yes.
So do you think then that 16 hours is an adequate amount of time for somebody who has never used firearms but now sees that it's a viable tool and option for them, do you think 16 hours is an adequate amount of time for them to reasonably be able to defend themselves with a firearm?
I think now that's a question. I think 16 hours is enough time to give them a introduction and an outline to the legal requirements required for ownership and possible the ramifications for use of that firearm. There's a lot more involved in the pulling of that trigger than what's taught in that 16 hours. I would highly encourage additional training for anybody that's their first exposure to firearms. I would encourage additional training with every bit of energy that I have. And please, 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 this might be the most important part of what I'm saying today. If that's your first exposure to firearms, yes, get some additional training, because the training that you're receiving is just an outline of the law. It's an outline of just the fundamentals. You need to get yourself much more comfortable than what you're going to receive in that training. So the training that you'll receive is just the fundamentals and an outline of what the law provides. It's not going to get you comfortable with that firearm and get you comfortable with the scenarios you could possibly face with that firearm,
which are going to be infinitely complex to begin with.
And again, when I'm sitting here and talking to you today, you need to understand that I'm coming to you from the experience of sitting beside you from the lawyer's table at a jury trial. And we've got to explain it to the 12 people that you and I picked out together. And I've leaned over to you and said, does that juror, are you okay with us putting that juror on the jury? And you and I looked at each other and said yes or no. And we only get to exclude 7 for no reason. And we're going to go through all 7 of those. I promise you that. I promise you we're going to go through all 7. And if we can't excuse them for cause because they don't like guns, they're prejudiced against gun owners, they can't stand they don't believe in self-defense. If I can't excuse them for cause, or they're biased against, for some reason that I can get out of them on voir dire, you and I are going to sit there and we're going to huddle together. And we're going to look at each other and we're going to pick 12 of those people to decide whether they're going to find you guilty of a charge. You understand that? And your life, if it's a murder, 1 indictment, that's incredible penalties.
You need to know what you're doing.
And you need to know what you're doing, and you need to know the questions that they're going to have to answer. Were you acting reasonable in your fear that death or great bodily harm was imminent? And were your actions reasonable?
And the reason why I asked this question to you is because in the short amount of time that I've been out of the military, it's been really surprising to me to see the number of instructors who, quite frankly, are not of very good quality. They don't harp on the legalities piece enough at all. They give more or less of their own personal opinion, and they don't emphasize to people that a 16-hour course is great for an introduction and a baseline of the fundamentals and safety. But you should really be seeking further training, whether it's with somebody you know who's experienced or and other training courses. You need to be able to expand upon your abilities, because tying your shoelaces once and not doing it for 6 more years, you're not going to know how to tie your shoelaces again.
Again, paper silhouettes are one-dimensional. They don't scream at you. They don't fire. They're not running at you. They don't yell at you. They're not moving. They're wonderful, wonderful things that don't do anything back at you. They're just there. They don't move. They're at 21, they're at 15, and they're at 10 feet. That's it. That's a lot easier than a moving target.
Who's assailing you out of nowhere.
Trying to assail you.
So it's very important. Just make sure that wherever you're taking your training at, just do a little bit of research on the instructor. Talk to somebody who maybe has gone through their course and they already have experience with firearms training, because they're going to be able to see things a little bit clearer. Look online reviews. Sometimes people who don't have a lot of experience, they go to an instructor and they think it was the greatest training that they could have ever possibly received. But please just make sure that you are going to a good instructor, somebody who is going to articulate things well and give you good legal training, good baseline, good fundamentals, good safety lessons. So, we've talked a little bit so far about the legislation when it first came out. We've talked about some of the Illinois requirements being 16-hour course and how you should always pursue follow-on training. Some of the other requirements are you need to be 21 years of age. That's also the age of owning a handgun in the state of Illinois. You need to not have 2 DUIs within the last 5 years. You need to, if you are a prior convicted felon, now this I have a question about.
This is an interesting question that you had on. I was intrigued by this question.
Yeah, and I get asked this, quite often, because there's a lot of rehabilitated personnel.
And I respect this, and I respect this question a lot.
So the question will be then, if I am a felon, can I get a concealed carry license?
The answer to that is technically yes, you can. And again, I want to reiterate this: that you got an uphill battle ahead of you. But the answer is quite technically yes, and I want to quote this from a. I want to read to you from. I'm going to just find my, because I want to from the section of the code from this. This is from 435 ILCS 6510C. Give me 1 second. It says that any person prohibited from possessing a firearm under Section 24.1, which is the 24.1.1, which is the felon in possession of a firearm statute, under the unlawful possession of unlawful use of weapons code, may petition for a firearm owner identification card review board for relief from that. They have to wait for 20 years, or excuse me, it gives you the requirements that they have to it gives you the requirements.
20 years after completion of the sentence.
20 years after completion of the sentence, and there are statutory requirements that you have to. Of course, you need to speak with an attorney about it, but there is a statutory relief. It is 20 years after completion of the sentence, and the answer to your question, and for all felons out there, is there is hope. If you can do this, I can't guarantee anything. I think it might be an uphill battle for you, but yes, there is a petition for review for you.
Do you see or hear of a lot of convicted felons applying for these types of licenses?
No, I don't, because I also do clemency review petitions for people trying to have them removed by the governors, and it's the same thing for those individuals as well. I think it would fall into the same category. It's such a long shot of getting it granted that I don't think people really know about this statute. I think if you were to contact your average lawyer and go, "I'm a felon, can I apply for a FOID card?" I think a lawyer is going to go. I think most lawyers are going to go, "No, you're a convicted felon. Mm-hmm. You can't apply for a FOID card." I think you're going to have a lawyer who absolutely, well, no, technically, if more than 20 years has passed, you can apply for the review board under the statute. This was a deep dive into the statute to locate this, to locate this review board. So I wouldn't be surprised if, as for 90% of most attorneys, for them to say the answer to be no, a convicted felon cannot own a firearm, and would not know that this relief is available to them through this statute. But especially since it's 20 years that have to pass before you know that relief is available. But on your show, the law is yes, you can after 20 years, and that's the answer I want you to give. And I want you to be able to give that statutory citation.
Yeah, absolutely. Having been, through, the criminal system a little bit as a young kid, as we had discussed, I wasn't the greatest young child teenager. When I was put into facilities that housed active child criminals, I came out of those facilities much worse. I did not come out of those facilities rehabilitated by any means. However, even though that persona still persists within the adult correctional facilities, that's not always the case. There are people who come out of the facilities and they don't want to participate in that lifestyle anymore. They've done their time. So for those of you out there, if more of you happen to apply for these types of waivers or these types of licenses, then the information will be more prevalent to people out there, and therefore more than likely through time maybe we could possibly get more of them approved for deserving citizens.
And there is the social justice movement is working towards life with treating people. Restorative justice is what I'm calling it. Restorative justice is moving towards restoring everybody's rights. A period of time passing, restoring your rights to vote in all states, restoring your rights to gun ownership and things like that. So there is a movement towards restoring these rights. So yes, I encourage people to at least contact an attorney to see if you qualify for filing that petition or filing it with the State Review Board. Again, look that statute up. The statutory citation again is 430 ILCS, Illinois Compiled Statute 65/10, subparagraph C.
And for those of you who don't know, those Illinois compiled statutes, that's the law. That is the legislation that was passed by lawmakers. That is it. That is the most raw material and guide that you could possibly have out there.
Exactly. Read it for yourself and then see where I'm getting the material from.
Let me ask you this question. If I was a 21-year-old man and I had suicidal ideations, life is rough, everybody goes through rough patches, and I commit myself to an institution saying that I need help. I do great, I'm released, it's been, a couple of years, I'm living a positive and productive life, and I say, you know what, I should really look into getting a firearms license here in the state of Illinois, because Chicago is leading in the amount of people who are shot and victimized by violent crime each year. Can I do that?
Has to be more than 5 years. 5 years in a mental health institution since your inpatient period.
So what about if I didn't commit myself, but I was committed?
That's still more than 5 years. Anytime it was an inpatient treatment, 5 years from release from the inpatient treatment.
That is not common known knowledge. So if you have ever sought psychiatric treatment and been in an institution,
and forgive me for this, for those of you filling out your application on that, because I'm dealing with an appeal on this specific issue right now, I want you to be very careful that outpatient treatment is not inpatient treatment. I want you to be careful about how you list your treatment. Outpatient treatment is not inpatient treatment. Unless you were committed, unless you were involuntarily committed, you could not leave, that's inpatient treatment. That's what they consider institutionalized. There is a specific definition within that code that for institutionalized treatment. Make sure you meet that definition before you answer that question, yes. Because that will deny you if you answer that question, yes. You will be automatically denied for your FOID card. And if you're denied for your FOID card, you don't meet the fundamental requirement for your concealed carry license. So be very careful with that question. I'm dealing with that specific issue right now.
So, and just to be clear, so if I commit myself to outpatient treatment, 5 years goes by, I can apply.
Outpatient is not institutionalized.
So it doesn't even matter.
No, that would be something. What my answer would be no. I wasn't institutionalized with outpatient treatment.
Okay, awesome. And I think that's a big point of confusion for some people, where if they seek any psychiatric treatment, whether it's outpatient, they mark yes on that questionnaire, which raises a whole bunch of flags.
And that's again, were you institutionalized? Outpatient treatment, I went home every night. I slept in my own bed. I was never put into the place. Was never put under lock and key by anybody.
And even if you were, whether you self-committed yourself or you were forcibly institutionalized, as long as 5 years have passed since your release,
that's correct.
then you could reapply. And of course, they're going to look into that, and they're going to see, were you a danger to yourself, other people? How are you now?
Most of the clear and present danger, a lot of them, and I'm dealing with some of the clear and present danger ones. I get those from the biggest clear and present dangers I get are from Chicago Police Department. They are the biggest ones. When I get an application, a concealed carry license application, it goes through the processes of it. Goes through the review process. Your local police department is contacted that, for example, Dan Collins has applied for a concealed carry license. I've been licensed since 2014. I live in Wheaton. The Wheaton Police Department has contacted Dan Collins has filed for a concealed carry license. They'll go through their database to see if there's been any reason why they've been called to my house, or been any reason.
Mm-hmm.
The Chicago Police Department will go through their database, and if there's been any reason at all they've been called to the address, they will object and file a clear and pleasant danger objection to it. And the most common reason is, a lot of times they'll be called to an address for a call for a disturbance, which might be an apartment overhearing a domestic disturbance in the apartment next to them.
Mm-hmm.
And it will be a domestic disturbance, a couple fighting or something like that. But when the police arrive, they'll separate the couple. Neither one of them will want to press charges against the other. Does that make sense to you? And they'll separate them. They'll write the report. Nobody wants to press charges against the other. We separated them. We left, and they leave for the night. There are never any charges filed. That's the end of the report. A report is filed, and that's it. However, based upon that report, the city of Chicago will file a clear and present danger objection to your concealed carry license. That now has to go to that objection will force you to file. Will go to the review board as an objection to your concealed carry license. And now, I've seen them object to a 2021 license as far back to a 2009 incident that didn't result in charges, that didn't result in arrest, was just a mere report. So you've got those objections to your application. That's all tied to, now your mental health goes back 5 years. That's one aspect of that. That's just for your FOID.
Yeah.
But the clear and present aspect of your address, that's going to go back with your local police department. How far back does that go? I'm seeing those go back to 2009 and 2008 on the clear and present danger objection available to your local police department.
And again, clear and present danger objection is just where the local police department says, we've been called out to this address.
And the evidentiary threshold for them to file a clear and present danger objection is reasonable suspicion. And just to educate you and the people watching this video on the evidentiary thresholds we have in Illinois, there's no evidence whatsoever. There's what's called a scintilla of evidence. That's for administrative law. Then there's reasonable suspicion. That might be something. There's probable cause. That's what's needed to arrest you.
Mm-hmm.
Then there's a preponderance of the evidence. That's 5149. That's what's needed for a civil case. There's clear and convincing evidence. And then there's guilt beyond a reasonable doubt. So they only need a very, very small amount of evidence to file this objection. Now, so they can take this report and file this objection to this to your application to the review board, and then you've got to respond to this objection. We've got to go back to 2009 and file a response to this objection to go forward with a concealed carry application.
If for something that could be even an erroneous call out to the address.
Exactly. Yeah, that's correct. Well, it didn't result in charges. Nobody wanted to move forward with it. It was a domestic. It was just just an argument.
Yeah. Is it difficult for that person who is denied, based off of clear and present danger? It's an erroneous, submission, right? It just called out to the address. Is it difficult for them to apply to the review board?
Once the review board makes a decision, yes, because at that point your choices are you can appeal that decision, and your appeal from that board would go to your local circuit court of venue. Yes, and because again, most of your circuit courts of venue are going to yes. You're starting to spend money at that point. You're going to start spending some money to appeal the decision and start moving forward at that point. Yes.
Yeah. But for all the viewers, just be advised that whether you institutionalize yourself to get help, 5 years after you are released, then you could apply for that void. Same as if you are involuntarily institutionalized. As long as there is no other objections by your local law enforcement agencies, there's no reason to deny you. So that's really great information. While we're on the topic of psychology, a lot of my students ask me about medical marijuana cards. Marijuana is legal now here in the state of Illinois. Medical marijuana has been legal here for quite some time, but because it remains federally illegal, there's a lot of information going around saying that you cannot also own a void or a concealed carry license if you have a medical marijuana card. Thoughts?
I have a couple. In Illinois, there hasn't been any developments yet on both a medical marijuana card and a concealed carry license. You can have both as of right now. I want to qualify that as of right now. Now, here's what I do think that you could run into some problems with is the purchase of firearms. And with that, and that is because of the federal requirements where you have to sign the addiction requirements for the federal purchase. You know which one I'm talking?
Do you use any illegal substances?
That's exactly correct. I would not want to sign off on that federal affidavit knowing that I have a cannabis card and then what they consider cannabis.
So for anybody who has a medical marijuana card in the state of Illinois, be wary of filling out the forms for when you're purchasing a firearm, because technically then it could be considered lying on a federal level.
That's correct. I think you might want to hold off on firearm purchases while you're in possession of a cannabis card. Are you following my advice on that?
Absolutely. So what would the penalties be for somebody like myself, not to say that I have a medical marijuana card, but if somebody who has a medical marijuana card filled out a form to purchase a firearm, and then somebody investigated it, they saw that they had a medical marijuana license. What could potentially be some of the issues they face?
Theoretically, they could face a felony charge for perjury or for the filling out a false federal firearms transfer form.
And then whatever firearms.
And then of course you're looking at forfeiture of all your firearms at that point for a federal firearms violation.
Wow. So be very careful if you have a medical marijuana card when filling out forms for purchasing a firearm. As Dan just said, you might want to hold off a little bit and see how legislation kind of plays out with that, because you definitely don't want to be marked as a felon.
And again, there is possible legislation for national legalization of marijuana. So I wouldn't purchase if you have a medical card. I just hold off on that for a while.
That's great information. So
now again, you could do it. That's my advice right now. Is I wouldn't make a new purchase
in a firearm.
Right.
Okay. So when we talk about, and we're going to talk a little bit more about the usage of alcohol and drugs when carrying a concealed firearm, how would it play out if I'm a medical marijuana card holder who's had firearms and a concealed license? Now I get involved in a self-defense scenario, and I am using my medication maybe just 20 minutes ago. Will the law view that as, almost voided because you were just using your normal medication, or will they view that as under the influence of a controlled substance?
Again, the question is all going to boil down to the reasonableness of your conduct. The question is were you in? I have the definition for the justifiable use of deadly force. Forgive me. I just want to make sure that I state it 100% correctly. Only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another. Was your use of deadly force to prevent death or great bodily harm to himself or another. Whether you're stoned or drunk, was it reasonable to believe that death or great bodily harm was imminent to yourself or another?
Okay.
You know, you could have the joint burning in the ashtray. Did the dude come crashing through the door with a sawed-off shotgun, and you tapped him twice in the chest?
Mm-hmm.
That's completely reasonable with the joint burning in the ashtray.
That's good to know. And not that I'm going to be sitting in my living room with a joint in my mouth.
But it makes, I don't, you know, that makes, you know, under something you could blow bong smoke in his face as you shoot him. It's completely reasonable.
Right, because there's the obvious threat.
Exactly.
And I do want to dive into you know, influence here in just a little bit, but let's kind of keep going on with some of like the legislation and some of the terms here that we're going to find. So we've discussed what the concealed carry law allows us to do. We've discussed what some of the requirements are. We've discussed what some of the questionable circumstances might be, whether that's being a felon or having seeked psychiatric treatment previously. What specifically, though, does the concealed carry law allow us to carry? You mentioned a sawed-off shotgun. Does a sawed-off shotgun qualify as a weapon that we can carry concealed?
Absolutely not. I've got a definition of what you can carry, more importantly, what you can't carry. Give me just 1 second to find it, because I pulled that definition as well. And I want to, just 1 second to find it.
Absolutely.
Is the law allows us to carry. Handgun means the law allows us to carry a handgun. A handgun means any device which is designed to expel a projectile or projectiles by the means of an explosion, expansion of gas, or escape of gas that is designed to be held and fired by the use of a single hand. Handgun does not include a stun gun or taser. That's interesting as well, because you would think that's interesting. A machine gun, as defined in Item 1 of Paragraph 7 of Subsection A of the UUW statute. A short-barreled rifle or shotgun, which that's an SBR. Mm-hmm. A pneumatic gun, a spring gun, paintball gun, or BB gun, which expels a projectile, which is just a BB gun, which is a 177. So those are the things that it does not include. So no, it would not include a sawed-off shotgun.
So let me ask you this then. A taser, a BB gun, those are non-lethal weapons or forms of self-defense. So why would the law specifically exclude those less severe types of items in comparison to a handgun? I think the taser is the taser, and I think the BB gun is for the protection. You think you're going to get yourself hurt carrying a BB gun? I think that's for the protection of the individual. I think that's foolish for anybody to carry a BB gun in that type of situation. I think you're going to get yourself hurt by that. I think that's for the safety of an individual. I think that's not wise to carry a BB gun in a concealed carry like situation. Yeah, we've seen many incidents where that actually ended up lethal, unfortunately.
So I think that's the answer for that. I think that's just foolish for anybody to carry a BB gun as any type of offensive or defensive weapon.
That's not a joke.
That's not a joke. Stun gun or taser. I think that's also covered by a different statute. I think that's considered outside the UUW statute by a different statute, which I think there's a statutory answer for why it's not covered by the CCL statute.
Am I allowed to carry a stun gun with me if I'm like a female, just like I carry a small can of mace?
Yes. Again, like I said, I think that's outside. I think there's a statute outside of that allows for carry of that.
Okay, and so perhaps that's why, is because there's no parameters within this guidance or this legislation, I should say.
That's correct. That's exactly why. That's correct.
Good. So that's good to know. So don't feel just by reading this that you can't carry a taser with you for self-defense and protection. You most certainly can.
Correct.
But also, as we said, though, for the BB gun, this is, you're basically bringing a piece of plastic into a metal world, and that's not something you want to joke with. It's nothing to be messing around with. There's plenty of case examples out there that ended up very sadly and unfortunately for some people.
Correct, and the sawed-off shotgun is a violation of the UUW statute by definition. Sawed-off shotgun is one of the most certainly illegal to possess in Illinois.
When you say UUW statute,
I'm talking about 720 ILCS 5/24-1 at sequence. We have an entire section dedicated to weapons, unlawful use of weapons statutes, unlawful possession by felons, unlawful possessions within a penal institution. 24-1 at sequence is the weapons part of the code section. So anytime you hear me, when I was preparing for this sections, I referred to different sections. I referred to the weapons sections. I referred to the concealed carry section. I referred to the FOID card section. So there's different sections of the penal code, the criminal code, and the different sections of the code all work together. When I practice law in this area, they all work together to the different areas. So it's not just the concealed carry code that I'm looking at. It's different areas of the law that work in conjunction with it for the definitions that I'm working with.
Absolutely. And so then by UUW, unlawful use.
Unlawful use of weapons is what. And forgive me. Forgive me for doing that. I just use it every day, and I will do that. If I don't mean any disrespect to anybody. It's just everyday lingo to me. UUW is unlawful use of weapons.
Yeah. The only reason I'm so good at identifying acronyms,
and
of course,
you're in the service, you do it every day.
And everyone's always looking at me like, can you explain that?
Yes, and that's correct. Unlawful use of weapons.
All right, awesome. So let's go ahead and take a step further then. Let's talk about section 66 and 65 in 430 ILCS, where it talks about those prohibited areas again. Now
yes, I think that's important. And let me give you an experience that I just had recently. My family and I went to a movie theater last weekend where this was an interesting experience because I carried to the theater, and the sign was in the bottom that said you couldn't carry into there was in the bottom of the door.
Can I reasonably see that?
Now that was my dilemma. I really wanted to carry into the theater because we recently, not too long ago, had a shooting in a theater that was in the general vicinity. So I don't carry all the time. I just don't. I just like being around my family without carrying. So I don't carry all the time, but that mall had a shooting within the recent history.
Oak Brook, which is one of the nicest malls.
Exactly. So, and the malls, and we were there. So I did decide to carry. So then I walked up to the door, and was it reasonable? But I saw it at the bottom. I even walked in going, that's not reasonable. So I couldn't be held accountable if I saw it. I walked up to the ticket counter, checked in, and then my conscience hit me, and I walked back out and I put it in the car. But the question is you're right, is that reasonable for them to post it at the bottom of the door at shoe height?
Because that's what Illinois state law says, is that for any area that is to be marked prohibited, like if I'm a private business owner,
and they're a private business.
Yep, and then I need to display a very specific sticker.
And it was the state guidance sticker. I will concede that it was the state guidance sticker. It wasn't a privately made one. It was the 430 ILCS mandated sticker.
And it needs to be somewhere where an adult or persons can reasonably be in view of it. So theoretically within belly to top of the head.
And it was in the bottom right corner of the door.
So let me ask you this then. Do you think that there are private companies who purposefully display incorrect logos, or they improperly place the logos because in reality they don't care?
I theoretically, had a client walked into my office with that case and a picture of that logo, I would have said we're going to trial in that case. I would have said I'm taking. Of course, I don't have a right to do that for my clients. My clients have to tell me, yes, Dan, I'll take the case. They decide what cases go to trial.
But you would take that case.
But I would love to take that case, and I would tell them I don't believe that is reasonably displayed. I think you have a very good chance of winning that case at trial, and I would love to be your lawyer for that case, is what I would tell them. Because I think I could win that case. Yes, absolutely. The Jewel Osco, and my Jewel Osco, I've read it. It has a perfectly displayed sign that looks completely legit, but it says this only applies to our vendors. So that all they're doing is putting up the sign says they're just doing a song and dance. So that the employees look, if customers look at it, you're more than welcome to carry in Jewel Osco.
And so now, maybe correct me if I'm wrong on this, but I had witnessed it downtown Chicago where it was a public facility. It was actually a hotel. I'm not going to say which one, but they had everything was spot on. It was the same measurements, the 4 inches by 4 inch square. The pistol was there, the little Ghostbusters no symbol, white background, but there was no ILCS 430. So is a sticker like that applicable, or are they doing that to appease the public, but really saying we don't mind?
No, the statute says it doesn't have to necessarily be that sticker with the 430 IL. It can be their own design as long as it gets the message. So I would say that sticker got the message across, and that would be an appropriate sticker to let you know that concealed carry was not allowed on that private property. Okay,
that's good to know, because I looked at that and I thought to myself, I could see a public vendor putting it up to appease the masses, right?
Right.
But also kind of putting out there as like a little wink in the eye flag to those who are educated. Look, come on in, we don't really care, but it's good to know that that's your interpretation of it.
No, my interpretation says, and I think I got statutory basis for that interpretation that says a private property, private facility doesn't have to require they can, as long as it has the requirement, as long as you can tell that it's not a concealed, they don't have to be that exact sign, as long as it conveys the message that it's a non-concealed carry property.
Okay, great. And so now, just to summarize this for our viewers, a lot of the times I get asked, well, how am I going to know if it's a no allowed zone or not, right? And I tell them, well, the law says that it's supposed to be reasonably placed. So if you're walking up to a facility and you're viewing, you're being aware of your surroundings, and you're not seeing that postage, then you're going to be good to go without diving into the specifications here, like we will, judge, judicial or executive branch, location. But that's my answer to them is, if you don't see it posted on the restaurant door or in the window, then you're probably going to be good to go. But always use your best judgment.
And I agree with that. For private properties, yes, they have a duty to post. I think if they don't want carry on their private property, then they have a duty to post. That's my opinion on that. I feel completely comfortable with giving the advice that if a private landowner doesn't want concealed carry on their property, then they need to post it on their property that they don't want it on their property. If you don't see it posted where it's reasonably posted, then feel comfortable. Again, it's concealed. That I want a proper conceal. I don't want it displayed. I don't want to see the bottom of your barrel coming out. I want a full concealed that nobody can see, but you feel welcome to exercise that concealed carry right. If it's concealed and it's properly concealed and it's not labeled on that door, then you should expect to feel welcome by that business owner. And I wouldn't be surprised if you were welcomed by that business owner.
Let's talk about schools.
Okay, very good. That's a good subject. Let's talk about schools because I think that's an important subject.
So, as a parent yourself, can you please explain to us what is allowed in terms of pulling up to the school, getting out of your vehicle, walking into the school as a responsible concealed carry owner?
You are allowed as a school, as a responsible concealed carry owner. Let's use the example that I'm picking my daughter up from school. I'm allowed, of course, to carry my weapon with me as I don't have to drive up to the school. I'm allowed to leave my weapon in the vehicle, in the glove compartment of the vehicle. Now, again, I want to make sure that because it's an important part of the statute. It says the locked glove compartment of the vehicle. So when I get out of the vehicle, I must transfer the weapon to the locked compartment within the vehicle, whether that's a locked compartment of the vehicle. Does that make sense to you?
Yes, it does.
Because I don't want. It says that in the statute, a locked compartment of the vehicle. And I could see that becoming an issue with an officer on the scene of something happening at a school, where somebody saw you put the gun in the glove compartment and called the police about seeing a firearm, and now the police officer is watching you retrieve it from your glove compartment, and that glove compartment wasn't locked. Does that make sense to you? And the statute, and when I was reading that statute from here, and it specifically says a locked compartment in the vehicle.
So a locked car doesn't constitute.
And that's why, and they don't make the distinction between a locked compartment and a locked vehicle. It says locked compartment.
So let's talk about schools.
Okay.
As a parent yourself, what is allowed in terms of, I'm carrying a concealed firearm with me and I need to go pick my son or daughter up at school, and I actually need to go in the school to grab them?
All right, so that's, and we'll use the scenario that we're driving to the school and we park and the firearm's on our hip at that point, and we're going to leave it because we cannot enter the school. And we cannot enter the school with a firearm. We both completely understand that that's a prohibited area.
Let me ask you this question. What about private schools?
Private schools are also prohibited areas. They are covered within one of the excluded areas explicitly by statutes. Both private and public schools are explicitly excluded.
So even private schools.
Correct.
Okay.
Now, here's the procedure that would be involved with you have two options. That could be one, you could remove the firearm from your hip there. You could place it within the glove compartment, and you could lock the vehicle. I'm clarifying the statute.
Mm-hmm.
You could lock the vehicle at that point. Two, you could place it within a container, i.e. its original case, and lock the container within the vehicle. Those are the two options options for storage. If you wanted to place it within the trunk, you are authorized to get out of the vehicle and walk to the trunk with the firearm, open the trunk, and place the firearm within the trunk or within a container within the trunk, and close the vehicle and then proceed within the school. The only movement you are authorized is from the exit of the vehicle to the trunk. That's the only authorized movement you are authorized.
I always tell my students, if you're going to put the firearm in your trunk, then you had better not be able to take your hand off the vehicle. You need to be within one arm's distance of your vehicle only as you move to the trunk.
And I think that's absolutely sound and very wise legal advice, because I would want to be, if I could put them on the stand and go, I was trained to never let my hand off that car, I think that would be great testimony to be able to give to a judge.
Good, that's great to know.
That'd be great testimony to give to a judge.
Stay magnetically attached to that vehicle, and
absolutely.
Then you're just trying to put it away.
And again, what I do is I just pop it into the glove compartment and go into the school.
So Illinois, the statute here, it also talks about any public gathering or special event on a property open to the public that requires a permit.
Okay.
So let's say that I'm hosting a retirement party for my dad at the local park down the street, and I have to get a permit. Or I'm hosting a block party, and I have to get a permit for the block party. All right. Is the Illinois law telling me then that I'm not allowed to carry my firearm with me in those areas?
You got a permit for that party, correct?
Yes, I did.
So yes, the statute would say that you're not supposed to be carrying at that party.
Interesting. Especially for the block party example, because you're within your own block, your
That's
own community.
Correct. Yes.
However, we cross out of the Concealed Carry Act and go more into a property type of legislation.
Once you're back on your own again, you fall into your property when you're on your own curtilage.
So the scenario that comes to my mind is I heard about 2 years ago now, there was a Chicago firefighter who was at a block party, and somebody was they came driving through that block party in a vehicle belligerently. It was very dangerous. They started yelling at that person. They actually came back and drove through it again. So they, threw like a beer bottle at the guy's car or something. Then he turned around, drove on to the actual lawn of the homeowner's home. But a guest, not the homeowner, a guest at the block party, a firefighter, engaged the driver with a firearm and ended up being charged criminally. Could that be because of the permit requirements there at the gathering?
Was it in Cook County?
Yes.
And did he kill the? Did he kill the? Did he kill the?
No, he didn't kill him. I don't even know if he wounded him, but I think he was arrested for reckless discharge.
And I'm not surprised that he was charged with reckless discharge. I'm sure he was charged with a couple of things. I bet he was charged with the unlawful carry, for violating the permit.
Mm-hmm.
I'm not surprised he was charged with the reckless discharge, because again, when that projectile, think about where he's at. He's in a residential neighborhood at a residential block party. He's on one side of the street. On the other side of that street is residential homes. I hope he asserted defense of others for the charge, and I don't know if he was found guilty or not.
Neither do I.
Because I think that he had most certainly. It's from what you just described to me, that almost sounds like a justifiable shoot to me. From what you had just described.
He had just driven through a block party,
and he had just driven, and he was driving at people on the lawn. I most certainly would have asserted self-defense of others, and most certainly self-defense at that point. But I can understand the reckless discharge, knowing that there were houses. He's coming knowing that there are houses on the other side of the street. Where there are people on those lawns on the other side of that car.
Mm-hmm.
Again, we go back to the education. We go back to the training. We go back to you needing more than that 16 hours.
Yep.
That goes into that mental process of you pulling that gun out of your holster, you lining those sights up. What's in that sight picture beyond that target? And do you need to... That goes into that thought process. Am I going to pull this trigger? If those bullets go past that truck and there's children on the other side of that street, or there's or there's a Vietnam vet on the other side of that street, or a retired firefighter's house on the other side of that street, and you hit him, was it worth pulling that trigger?
Yeah, I always tell my students the fourth weapon safety rule is to know your target, consider the foreground as well as the background, because bullets go through things.
And that's incredibly important, both in that scenario as well as we're going to talk about highway shootings later. But that's always when you discharge on a highway, highways aren't in a vacuum. There's other vehicles on that highway as well as houses, and people live beside highways.
In your experience, what caliber of firearm is most often associated with hitting bystanders or passing through an assailant and hitting a bystander? If there is one.
No, it's because of the fact that it's the most popular caliber with it's the 9mm, and it's because of its prevalence. It's because of its prevalence.
It's like the most common caliber.
It's the most common caliber. It's not because of its it's not because of its power, or it's not because of its lethality. It's because of its prevalence, and it's because of its prevalence.
Which, and give me your opinion. I tell my students quite often that when you're dealing with a life-threatening situation, the majority, I think I read a statistic from a study taken a few years back, that most violent crime encounters, like well over 90%, are 5 feet or less, because that's how you get mugged, that's how you get assaulted. It needs to be within 5 feet. And if you're going to utilize a firearm in self-defense at this distance, it doesn't matter if it's a 40, 45. I mean, granted, yes, there will be some differences, but it's passing through that assailant. That's
the ridiculous. Lead on target wins those fights.
Yes.
And I'm a firm believer that .380 is the ideal caliber for personal concealed carry.
Why do you say .380? .380
is a short 9. It has a quicker reset. For most people are going to carry semi-automatics, and I think it's a quicker reset than a 9mm. And lead on target wins. Most gunfights in personal concealed carry are won on the second shot. And that second shot, it's the quicker reset. The quicker reset comes from that .380. .380 is going to be a quicker reset on that second shot than a 9mm.
The thing I like about the .380 is that I'll do ballistic studies, and the .380 is kind of like almost has like a .22 or a .556 type of characteristic about it, where it doesn't become fragmented very easily, it'll actually hit the bone. It'll bounce around quite a bit as well before making an exit. So that was one thing I found interesting.
I think it's the fastest lead on target, and from the distance you're talking about, that's what's going to win the fight for you is lead on target.
Yeah, the minimal increase of the bullet hole from this distance. They're designed to make an impact at a certain distance.
Correct.
You know, and that's one thing I definitely always tell my students. But again, always be aware of your target. Consider the foreground and the background. If you're one of my students, you definitely know all 4 weapon safety rules, and you definitely are familiar with that one. We do a lot of scenarios with that one. Let me ask you about this one. This one I found interesting in terms of prohibited places. Public playground. Child abductions there's thousands of them a year. And a lot of them do take place in broad daylight on a public playground. What's your interpretation of this?
But the last place you want to have bullets flying also is a public playground. I think that's a public safety thing. Again, the Illinois legislature did not want to grant concealed carry.
Mm-hmm.
When they were forced to grant concealed carry, all right, let's make the list of where you cannot carry. And they did it with public safety in mind. And a playground is one of those areas where you can sit there and go, okay, I don't want a bunch of parents sitting around with handguns on the thing. You know, that's just one of those places where public safety is going to win out over. You're happy you got the right to carry, and you're going to be like, all right, I'll give you playgrounds.
Mm-hmm. Yeah, so in other words, when Illinois was passing the law, they wanted to create as large of a list for prohibited areas as
right,
they possibly could.
And hopefully we're willing, like for an example, the Forest Preserve of Cook County was just found to be unconstitutional.
Oh, I did not know that.
So that was just a case that just came out of Cook County. It's going up to the Supreme Court, but the blanket prohibition was just found to be unconstitutional. So we are, and again, we've been. I'm a student of the concealed carry. I really am. I watched throughout the state how the shootings are going down, how it's been reacted for the last 8 years, and I've been quite impressed. I've been quite happy with how the concealed carry holders have been doing with how they've handled themselves with their shootings, and how disciplined they're trigger discipline. As I'll call it, trigger discipline. You know what I'm
Mm-hmm.
talking about. I think they've done fairly well. I'm disappointed with the highway shootings. I'm disappointed with the number of shootings that are going on in the highway systems, especially around Cook County and Chicago. I think people are starting to shoot at each other way too easily on the highways.
Are these concealed carry holders that are doing
this?
this?
I don't know that. I can't answer that, and I hope not. I hope that people aren't just throwing lead out there on the. I hope that we haven't lost our discipline, and that we've resorted to that. I don't know that. But I'm concerned about the increase, because that's something that's recent. These highway shootings, that's something that has not been in our history. That's within the last four to 5 years that those numbers have increased drastically.
2020 was a crazy year for that.
Drastically, those numbers have increased drastically, and I'm disappointed by that. And I'd like to see us take responsibility for it. I'd like to see that change. But other than that, I've really been happy. I think that it has had a positive effect. I think it's had an empowering effect, to be honest with you. Just like you said with your mission, it's had an empowering effect for a lot of people, and I think that's been a positive thing.
Where do you see that taking place? Is it within your experience in the courts, in the judicial system? Is it through the case studies and just following along with the public information available?
Well, yeah, because I see the empowering. It's not going to be in the court system that you're going to see the empowering effect, because the empowering effect is because it's if you're empowered correctly, and the concealed carry license holders are doing everything that they're trained to do properly, then you're not going to catch a case. I want to make sure that I said that correctly. If you are doing exactly what's required to you based upon your training, and if you're doing what I'm asking you to do, is get some follow-up training, so you're acting rationally, then there shouldn't be any question that you are acting in fear for your life, or in fear of imminent death or bodily harm, and your shoot is completely justified. Then then you shouldn't catch any charges at all. You should be questioned. You should lawyer up, but there shouldn't be any questions about the facts. There shouldn't be any questions about you not catching a case, and you should be going home to your wife and family. There should be no question about that.
Absolutely.
If you're trained and you do everything properly. And I think that that's been the majority of the cases for Illinois concealed carry holders. And for that, I commend the instructors in Illinois. They've done a remarkable job.
That's good. That's great. You don't always run into that all over the nation.
No, because there has been some issues. There have been some issues with some of the instructors that I'm aware of as well.
So let's talk about that since we're already on that topic. We've talked about prohibited places a little bit, and there's many other prohibited places. Make sure you check out that Illinois compiled statutes, okay, and find out for yourself.
And I do want to make sure that we talk. I want to just give you a final note on that, because that list is long and extensive, and the duty is on you, the concealed carry license holder, to know that list. You must be aware of that, because the penalties are great. You are eligible for supervision, which supervision allows you not to have a conviction entered upon your record. But it does result. It will result in the suspension of your concealed carry license, and it can result in the suspension of your concealed carry license. And the second one will result in a conviction. So there is most certainly penalties associated with it. So please familiarize yourself with those prohibited areas. It's really important, and take that serious as well, because that has an effect on the rest of us concealed carry license holders. Your respect for those prohibited areas,
and therefore the safety of the greater public.
That's exactly correct.
Yeah. So, and then just to hit like some of the wave tops before we finish off on prohibited places. Any executive, legislative, judicial, state buildings you cannot bring a firearm into. Any federal government buildings you cannot bring a firearm into. Any establishment that makes more than 50% of their revenue off of liquor sales
within the prior 3 months.
It's that owner's responsibility, however, to be posting the
that
appropriate
is correct
signage.
as well.
Like, I don't need to go into a restaurant that serves food and liquor and say, hey, do you guys do 51% of your sales? That's their responknow at that point in time.
That duty is not on you.
Any other really big ones that you want to hit on real quick?
Stadiums, because again, you go to I know that you might be tempted to take it to a Bears game or a Cubs game or the White Sox because of the increased violence associated with professional sports. No.
But the public gathering, it seems there's a theme here.
There is a theme. Public gatherings, you can't do that. Horse tracks, betting facility, horse tracks, no. Things of that nature. That's things of that nature.
Okay, great. So remember, again, make sure that you verify with yourself. It's up to you as a responsible concealed carry licensee that you know when and where you could be carrying the firearm. Otherwise, you could be subject to some criminal charges. So going back to the instructors, I love to hear, even as an instructor, I love to hear when there's great instruction being had. I could care less if all my instructing competitors, if you will, were destroying me in business, but they were giving just great, thorough training. That would be some great news to me. What are some examples or experiences that you may have had that are both good and bad with Illinois concealed carry instructors thus far?
And I apologize for this, but mostly the experience that I've had is been on the poorer side than it has been on the better side. I've complimented those instructors that have been involved in the shootings, because they've been good shootings. But the ones that I've been involved in have been the ones that have gotten their client. I'm defending their students. I'm defending their students for DUIs. I'm defending their students for improper carries. I'm defending their students for things that should have been trained. Should have been trained in class. Mm-hmm. If you're going to go drinking out with friends and they're going that DUI, if you don't get a DUI with your concealed carry with your firearm in the car.
Is that an increased charge, unlawful possession, or?
It's not an increased charge, but it does result in the suspension of your concealed carry license. You cannot have it. You can't have your firearm with you with a DUI in the car.
Okay.
And that's something that you would think an instructor would bring to your attention, because it makes sense. You don't need to be driving around under the influence with the firearm in the car.
Does Illinois statute give us a blood alcohol content
Mm-hmm.
when carrying a concealed firearm?
It doesn't. It doesn't make that distinction between it. It doesn't make. It doesn't. There is no. I'm sure you're asking as a question, or does that take it to a reckless discharge question? No, they don't. There is no per se. If you have a firearm on you and you have .04, that automatically classifies you as a reckless carrying or something like that. It does not. But it does. There is a section in the concealed carry section that does make you liable for a DUI while concealed carry.
It's good to know. What I like to tell my students is, if you plan to go out drinking, why even bother taking the firearm with you?
And I think that's the best advice, because I think that's the wisest advice. Again, I think that's the best advice.
Yeah, I
leave
can't.
it at home.
I can't ever imagine a morning that I woke up from a night of heavy drinking and said to myself, man, I really just made great choices last night.
Right,
Exactly.
exactly.
And the last thing I want to do is incorporate, one of the most important and impactful, aspects of my life while drinking. So I always just tell my students, if you plan on going out drinking, don't bring the firearm with you. You're only doing yourself a favor at that point.
And I think that's wise. I think that's very good advice. I think that that is good advice. It is a privilege. I mean, I know it's a right, and I know that it's a constitutional right, not a privilege. But they will take it from us. They don't have a problem taking rights from us. They don't have a problem taking that concealed carry part from us, and the burden on us trying to get it back. Fighting those appeals, fighting to get that back, is a pain. You don't want to get involved in the appeal process. You don't want to get involved in the revocation process. You don't want to get involved in trying to be involved with the firearm bureau of the Illinois State Police. They're hard to communicate with. The letters take months to get replied to. Trying to get somebody on the phone is next to impossible. You're better off just trying to abide by their rules. Trying to just, and again, I know it. I know I'm not. I know it's. I know I'm a lawyer. I know it's my job is to fight the unjust rules. But sometimes, especially in a scenario where I'm talking about fundamental rights to protect your family, fundamental rights for you to protect yourself, I'm trying to ensure that you have those rights available to you every day. And I'm telling you the best way to protect those rights when it comes down to, is to just try to go along with their rules to the best of your ability. Mm-hmm. I know there's sometimes when you can't do that, but if you can do that, try to go along to their rules to the best of your ability.
So let's talk a little bit more about this then. Illinois law doesn't define a certain blood alcohol type. They just say that you cannot be under the influence
Correct.
Of alcohol. And that, of course, will be subjective dependent upon the total context of the situation that you happen to find yourself in. So again, I always say, if you plan to drink, don't bring your firearm with you. When it comes to instructors not meeting the requirements or not adequately training their students, how are they handled? How can students possibly identify instructors that are better than others? How does the state of Illinois keep those instructors in line?
Well, the state of Illinois, most certainly, they have a review process. Of course, there are the requirements for the instructors. If an instructor is falsifying student records, that would be one issue. Does that make sense to you?
They're just signing certificates.
If they're just signing certificates, then that's a substantial issue. Then there would be that would be one issue. Then there would be the issue if the instructor himself is falsifying his credentials. Okay. So we've got two issues. We've got two separate issues here.
Have you seen both?
I haven't seen where the instructor is falsifying student credentials. Mm-hmm. I've seen where the instructor is falsifying his own credentials.
Wow.
Okay, and in that case, the instructor has been immediately revoked from ISP and lost his credentials. That's been the result of that. However, they have not revoked the credentials of the students. So that's been the result of that.
So even though the instructor was invalid in their credentials, and I'm a student who went through their course of training, I will still be able to retain my concealed license.
Correct, because remember he was granted based on, even though the credentials that he submitted were not legitimate, he was granted a legitimate license, and they don't know it, and the students were granted legitimate licenses. Now I think there's a question about whether you can go back and revoke those legitimate licenses once they were granted, and I think that's the legal question as to why they can retain those licenses, but they will go out. They're going to have to do the refresher class and everything once those licenses expire.
I think most importantly also to kind of really hone in on all this with improper instruction is you're not getting good training, you're not getting good teaching, and you're probably going to become a liability now and thinking that you have a capability and you actually probably don't. I think that that's one of the most important things in validating the instructors that you're receiving training from.
Yes, and I agree with that as well. I absolutely agree with that. Again, you're only as good as your instructor. And I think that's the most important thing. You're only as good as your instructor.
So you said something a moment ago about Illinois State Police responding. So the law says 90 days to be approved or denied by Illinois State Police. So once I submit my Illinois concealed carry credentials, I've taken the right courses, got all the good documentations, I'm legitimate. It says that it'll take them 90 days to either approve or deny. However, right now, people are seeing up to 6 months, 7 months because of COVID. They've restricted the amount of personnel approving. Do you have any advice for anybody, or have you seen anything unusual in people applying for licenses since the beginning of COVID?
I've seen incredibly, not in the application process. I'm surprised to hear that the delay is in the application process. I thought the application process was still going smooth. I'm surprised to hear that there's been delays of that length.
Oh yeah, I've had students who, and it didn't matter if they were fingerprinted or not.
Really, because I thought that I would be recommending them to use the TCN process, the fingerprinting process, instead of going. I think I could understand that delay if they used the old-fashioned fingerprint process.
Yeah, so I've had students who were fingerprinted in the new with TCN.
Right.
And it took 9 months.
Really?
9 months. And then I had students in the same course who didn't get fingerprinted because, keep in mind, it's not a requirement to get printed. Although they do say it expedites the process. But that student who was not fingerprinted, and there's been a couple of cases like this, it's not just an isolated incident, 4 months they received their license. So when I talked to ISP via email and the instructor portal, they just explained to me, look, like we're limited staff, so we're seeing all sorts of different wait times.
Okay. That's the only explanation they gave you?
Yeah, normally I guess they have 10 people working in the office, and now they only have 2. Again, I don't know exactly how valid that was. It could have just been an answer given to me by anybody via email.
Okay. I can't give you an explanation for that. I'm aware. I know that the appeals have gotten ridiculously long. That their appeal process is ridiculously long.
We talking a year?
Yes,
wow.
Longer than a year.
So if I'm denied and I attempt to appeal, I've got quite a while to wait.
You've got a long ways to wait. A long wait ahead of you. Almost to the point where it's monstrously long. Almost to the point where you're wondering, are they communicating with me long? It's that long.
So make sure that when you're filling out your application and going through your records,
go through it twice. I please go through it twice. And it can't. If you feel like you need to have somebody review it with you, contact somebody to review it with you. It's worth it for a consultation just to go over the application. Go. Am I answering these questions right? Have I done this right?
Is my photo correct?
Yeah, that's exactly correct. Even something as simple as the photo can just slow you down. But if you do it right, it can be done in no time. I just had to renew my FOID card, and I got it back in less than 3 weeks.
And I read recently that they're now combining CCL and FOID cards.
And I was hoping that I would get one of the first combined ones.
And
I didn't.
Okay.
So I was hoping for it. But the number is the same, and my new FOID card doesn't have an expiration date on it.
Yeah, that's what I was also reading, is that they've just basically combined them.
Okay.
So if you have a FOID now being issued and you don't get the combined ones,
Right.
it won't have the expiration date on it because they're going to regard your CCL expiration date.
Oh, is that what they're going to do? So
Yeah.
I was looking at it last night, and I was like, why? It doesn't have an expiration date on it, and it has the same number as my CCL on
Is
it.
this even legitimate?
Yeah, right, exactly. So that's what they're doing with those right now, so because I just renewed that as well.
Yeah, so for anybody watching, just be aware that as you go through the renewal process, especially because the Emergency COVID Act, a lot of people who have had expired licenses have still been valid.
Right.
Because based off of the COVID Emergency Act, correct me
Well,
if I'm
actually, it's in the
pronouncing that
CCL statute that it remains, as long as you've applied for it, it's right there, it remains valid.
then it's still valid. So as they start getting back to full speed and shoveling all these things out, you'll likely find yourself with one, which is beneficial to me because now you don't have to worry about two forms of identification,
Correct.
technically three because you need a driver's license.
Right.
So just be aware of that's the new phase that's coming in.
And today should be we're back there to remove the mask mandate today, so hopefully we'll start getting back to normal starting today.
Yeah, that's right. That is right. All right, let's talk about use of force.
That's what that's what we need
Yep.
to discuss. This is the big one, because this is the one where we get into the meat and potatoes of when you can use force, and that's what this is all about.
So before we dive into just what the actual definition is within Illinois compiled statutes, let's talk about, I see this thing called a forcible felony.
That's good. You want to go to the definition of what a forcible felony is?
Let's define that.
Let's go find that definition. Because what is a forcible felony? And now this forcible felony is a legal term more than it is. Forcible felony is a term for is a word used to describe a group of felonies.
Mm-hmm.
So it's not a one specific felony. It's a word that describes a group of felonies. And the forcible felony means treason, first-degree murder, second-degree murder, predatory criminal sexual assault of a child, aggravated criminal sexual assault, criminal sexual assault. And here are the important ones. Robbery. Here's a very important one. Burglary, kidnapping, aggravated battery resulting in great bodily harm or permanent disability or disfigurement, and any other felony which involves the use or threat of physical force or violence against any individual. Now, the reason that the forcible felony is important to us is it goes into our analysis as to when you can use deadly force, lethal force,
Yep.
lethal force. And again, the felonies that are going to apply to a person within a home environment, within a dwelling environment, most certainly would be robbery. Somebody's in your home, they're going to rob you. Robbery, and robbery is different than burglary.
Yeah, expand on that.
Robbery is when I take money from you by way of a burglary is entering into the property of another and then committing a theft therein. Does that make sense to you?
I don't need to be present or in the situation.
And robbery is taking it from your person by threat of violence.
Okay.
Does that make sense? So whenever you hear those terms all the time on TV. I walk into my house and I was robbed. You weren't robbed. You were burglarized. The robbery is when they take it from your person by threat of force. Burglarized. You were burglarized when somebody broke into your house and stole it when you weren't there. That's what that means by that. So, but when you're in your home and somebody comes into your home, then that's a burglary. Do you wonder? Does that make sense to you? And burglary is a defined forcible felony.
Yep.
Therefore, that's your authorization for potential for the use of deadly force. Does that make sense to you? That doesn't include sexual assault. That doesn't include robbery. That doesn't include kidnapping. That doesn't include great aggravated battery, great bodily harm. This guy coming in to kill you. Does that make sense to you? Or we're not. I don't even see home invasion on this. Does that make sense? Which would be another major felony. Another major felony on this. Again, forcible felony is just a list of those included felonies that are considered dangerous felonies for what somebody would have on their mind when they're coming through the door of your house. That gives you the right to use lethal force in defense of your dwelling or it's a term that we use when we're talking about defense of self.
So this is basically the list of criminal acts that the Illinois government came up with and said, look, these are severe enough. We're going to umbrella term them under forcible felony because we think that all of these are going to be worthy of using lethal means in self-defense.
Yes, and I think that's a good way of looking at it. Instead of us, that's the term for this group of felonies that warrant the possible use of lethal force.
Okay, great. So now that we've defined forcible felony, because that's present in every single of the times where you could use lethal force, let's talk a little bit about in defense of self. So we can use lethal force in defense of self either to prevent or to stop the act of a forcible felony being conducted on us. Is that correct?
That is absolutely correct.
So for example, if I'm being criminally sexually assaulted, if I'm a woman and I'm walking to my vehicle and I'm thrown to the ground and I'm being groped and touched and it appears that this person who's assaulting me is hurting me, that they have a sexual intention, I'm a licensed concealed carry holder. I can then utilize possibly lethal self-defense in that scenario.
Yeah, if he's engaged in the act of a criminal sexual assault, which that would make what you're describing would meet the definition of a criminal sexual assault, she would have the right at that point to engage lethal force.
So going back to our example where we talked about the woman in New York or Philadelphia last month. Now, I've been asked this question quite a few times. Excluding the fact that the CTA or public transport is a prohibited area, let's just say that we're in an area where we can carry a concealed firearm and we're witnessing a sexual assault like that take place. Do I have a legal duty and responsibility to attempt to get the person off, the perpetrator off of the victim, or am I immediately allowed to use lethal force in self-defense, in this case of another person?
Now you've got two questions here, and then I want to go over my answer to these questions too. Let's talk about this. Are you saying a good Samaritan, as in, do I have a duty to step in, or can I step in with the first question, or do I have a legal duty to step in and try to rescue her?
Can I? Because I'm pretty sure there's no legal requirement.
You are correct. There is no legal requirement to do that. In Illinois, we have no duty to render aid.
Right. But
Okay.
God, I hope that people would.
And you know what, you and I are both. I would pray that people have that in their heart to render aid in that situation. Now, can you render aid? And if you have it in your heart to render aid, are you protected by the law? And the defense statutes and the self-defense statutes, use of force in defense of himself or another. So if she has the right to use that force, you have the right to use that force in defending her. So you would have every right in the world to go grab him and pull him off her.
So let's say now, so we've talked about in defense of self, now we're talking about in defense of another person.
That is defense of another is correct.
If I'm witnessing the sexual assault take place, can I just go up and immediately use lethal force to get the criminal to stop? Or do I need to try some sort of escalative means, like try to maybe kick them off or pull them off? Do I need to put myself in any risk whatsoever before I just immediately go to using lethal force?
You have the right to use the force that's available to the person experiencing the assault. So you have a right to step into their shoes. If they're authorized to use lethal force, you would be authorized to use lethal force.
That is an amazing, I can't, you just gave, that was perfect. I've never put it into that context before. So, and this is something I get asked about all the time because I want to train people how to help one another with firearms, right? And so people are asking me in defense of other people, which is a precarious situation because you don't know the totality of the circumstances if you didn't witness them. But what you just said was if somebody is being assaulted or if there's a forcible felony being committed or about to be committed to somebody, I put myself into their shoes. And if that person has the legal permissibility to use lethal force, then I as well have that in their defense.
That is absolutely correct.
That's awesome.
And again, that could, only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another. That death or great bodily harm to another is occurring at that precise moment, and that person would have a right to use that force. And they stepping into those shoes, he's using that force for that person.
That's such a great definition. I thank you for that. I'm going to definitely use that forever.
Yeah.
Put yourself into their shoes, and if they are legally permissible,
You're legally permissible.
That's amazing. So remember that in defense of yourself, if you're going to stop, prevent, stop or prevent or intervene on that forcible felony being committed against you, by Illinois state definition, remember, it's up to you as a responsible owner to know these things. You can use lethal force in defense of other people. Put yourself in their shoes. If they are able to use it because the circumstances are there, then that transfers over to you. So that's a great way to look at it. No questions should be there. You can't be sitting there saying to yourself, well, maybe if I approach them this way, it won't go well for me legally in court. No, if they have the right to defend themselves lethally but are incapable of doing so for a number of reasons, you now have that ability. Let's talk about in defense of property, okay? So we've talked about in defense of self, in defense of others. Now, in defense of property, please explain how Illinois defines use of lethal force in defense of our property.
Well, there is the castle doctrine. Every man's a king in their castle. You have a right to defend your castle. Does Illinois have a castle doctrine per se? And you do have a right to use deadly force in Illinois to protect your castle. If a person is justified in the use of deadly force which is intended or likely to cause death only if the entry is made or attempted in a violently riotous or tumultuous manner, and he reasonably believes that such force is necessary to prevent an assault upon or to prevent personal violence to him or another than in the dwelling, or he reasonably believes that such force is necessary to prevent the commission of a felony in the dwelling. So therefore, that's the castle doctrine in Illinois. If you're getting a violent assault upon your home, or you believe that you're preventing the commission of a felony in your home, you have the right to use deadly force.
It doesn't say forcible felony.
No, it doesn't say forcible felony. Doesn't say forcible felony, and that's a distinction in the defense of a dwelling. Does that make sure we know that distinction? The entry or is made or attempted in a violent, riot, or tumultuous manner. That's a home invasion. That's them trying to kick in your door and
break in a
window and that. And he reasonably believes that such force is necessary to prevent an assault upon or an offer of personal violence to, I'm coming in to blah, 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 him or another there in the dwelling.
So let me ask you this. If it's 3 a.m., and somebody doesn't smash a window to come into my home, but I hear them moving around, jingling some stuff in the kitchen, and I go to confront them with, my firearm. They didn't make entry in a riotous or tumultuous manner. I can't necessarily tell if they have a firearm or a knife or a weapon with them, but I can tell that I do not know this person. They should not be in my home. Do I need to validate or to verify exactly who they are and what their intentions are within my home before I could use lethal self-defense?
Listen, now you're getting into a little bit more of a gray area here, but let's go to prong 2 in this. Or he reasonably believes that such force is necessary to prevent the commission of a felony in the dwelling.
It doesn't say you need to witness the forcible felony.
It doesn't say you need to witness the commission of a felony. You need to wait for the commission of a felony. It says to prevent the commission of a felony. You don't know what he's doing in your house. You don't know if he's there to steal your silver. A theft over $300 is a felony.
Absolutely.
And in fact, he's already committed a felony by breaking into your home. He's committed a class 1 residential burglary. So a felony's already been committed by the mere act of him entering your home.
I tell everybody all the time that if somebody's in your home unwarranted at a strange time of the night, then you shouldn't be sitting there asking them or wondering if they have ill intentions. Back in 2020 over in Lombard, just right down the road, it was about 2 a.m. and 2 out of the 3 suspects kicked in a random door into a suburban home, went in, and then started assaulting a guy's daughter in her room. And the dad woke up, ended up fighting with the guys. They ended up, leaving in a panic. And then they got in the car, drove literally less than a mile down the road, kicked in another door, Granted, yeah, that's entering in a tumultuous manner. And then began to do the same thing. So don't think that these situations are uncommon. They do occur. If somebody's in your home and it's not warranted and you don't know who they are, my advice is to always assume that they have the worst intentions possible for you and your family. Now, with that also being said, being a Marine for 13 years, I know quite a few guys who like to drink a little bit. And I know quite a few guys who ended up knocking on the wrong door, going into the wrong garage, or passing out on the wrong person's couch. Not advocating that behavior by any means, but just be aware that if you have somebody who's attempting to enter your door and they sound intoxicated late at night, always use your best judgment, keep safe distance, observe, but they might just be at the wrong home. So that doesn't necessarily mean everybody coming into your doorstep is going to be a lethal threat. Which brings me to my next point. If somebody's in my vehicle and my vehicle is parked safely in my driveway, it's 2 a.m. and my alarm goes off, I go outside and I don't even ask questions. I just decide to confront with lethal force. What are your thoughts?
I think at that point, I think you've got a problem. I think that use and force of defense of other property. When are you justified in using lethal force in defense of other property? He is justified in the use of force which is intended or likely to cause death or great bodily harm only if he reasonably believes that such force is necessary to prevent the commission of a forcible. Now we're back to a forcible.
Yep.
See how
it's not in the home.
Right. See how they've added that higher threshold because you're not in the home? And what forcible felony are you
preventing? Robbing some change?
Right. They're committing a theft.
Yes.
It's because it's a vehicle.
Yep. And that's a great point, because in some states, castle doctrine applies to your whole property, as
Correct.
in the physical confines of your property.
But not Illinois.
Illinois
is strictly the house.
The law says it pretty clearly that if they're attempting to make unlawful entry or commit a felony within your home, again, felony, those are the times where you need to be using your best judgment and possibly be using lethal self-defense. Now, vehicle parked safely in the driveway, they're robbing my vehicle of some change, or even some people keep firearms unsecured in their cars. That doesn't give you necessarily the right now to use a lethal means, because you leave an unsecured firearm in your vehicle and there's a theft taking place. Correct me if I'm wrong.
I agree. No, I agree. Unless he attempts to use that firearm against you, but then we have an entirely different scenario at that point. Now we have a self-defense scenario. But him just in your car on your driveway, that's it might be is that a burglary? That's not a burglary. That's not a residential burglary. That's a class 2 burglary at best.
I know morally I wouldn't feel okay with myself.
Yeah, I think you're crossing the threshold into an indictment at that point.
And I would agree. I think that's a little too cold.
Right.
There's no immediate threat to you.
Yeah, I know that burglary was considered within that definition of forcible felony, but I don't think burglary to motor vehicle is considered within that definition.
Yeah, you putting yourself out there and exposing yourself, now we're talking
exactly.
A little bit.
I agree with that. I agree with you on that.
But now let me ask you this. Castle doctrine, does it apply to my vehicle if I'm driving about my business daily?
I see it now. Castle drive strictly applies to dwelling. Strictly applies to residential dwelling.
But is my vehicle considered an extension of my dwelling?
So I disagree with that. No, and again, I'm going to go back. I don't think the courts are going to apply that to a dwelling. I don't.
So if I'm sitting at a stoplight, for example, and all of a sudden somebody comes up and they're attempting to enter my vehicle in a riotous or tumultuous manner.
Okay.
I don't have time to verify they're pointing a gun at me.
Okay.
But they're clearly attempting to carjack me from my own perception.
Okay.
What does the law protect us in that? How does the law protect us in that circumstance? And what do we need to be aware of?
I think that since you are outside, again, I think that you are, at that point, you are use of force in defense of other property. You're defending the property, you're defending the vehicle at that point. So I think that you've got to, you're a reasonable belief that you're a commission of a forcible felony. So at that point, is he armed? Is he armed? Then he's committing a robbery. He's attempting to deprive you of that property by, that's an armed robbery.
Absolutely. And that's something I get asked all the time is, well, don't I need to verify that they're pointing a gun at me? You don't. It just says that, reasonably perceived danger.
Right. I thought I was being carjacked.
And somebody coming up to your vehicle and ripping you out of it, or putting their hands in your vehicle.
That's a carjacking. That's me. With this day and age, them trying to reach for that handle to open that door. You're attempting to take me out of that vehicle. You're not walking away. And
just be aware that a lot of carjacking victims are being shot for no reason whatsoever. Working over in the west side of the city last year, we had a Uber driver who was carjacked by a 15-year-old and a 14-year-old, and they shot him in the head, killed him. And when they were later arrested, they said just because.
Yep.
So be aware of that. Don't wait for these moments and these opportunities to verify that somebody might be potentially ready to kill you or harm you very severely, or somebody you love. Follow the law. And we just covered the 4 times that you can use lethal defense in Illinois. In defense of yourself with those set of circumstances, in defense of others, in defense of your home and your dwelling, and then in defense of other property, that being your vehicle. Now, let's talk about if I witness somebody breaking in and conducting burglary on my neighbor's home. I know they're out of town. I'm witnessing a burglary take place. What are your thoughts on using lethal defense in that case?
So use of force in defense of another person's problem, use of force in defense of dwelling of their problem, their property, the property of another. I would feel comfortable with. Are you entering in their property to catch that person in that property?
That's a good question. In the scenario that I'm drawing up, no. I'm seeing them from my home, and then I go out to confront them outside of the person's home. And making a citizen's arrest? Just attempting to, say, hey, get out of here. What are you doing? I don't necessarily recommend that by any means. I think that that's a horrible idea. But there have been times where people perhaps don't think that they will be, shot or stabbed or beat up. And so they go out there and they start yelling at burglars. And then all of a sudden that situation, can either escalate, or let's just say in this case, they just immediately start utilizing lethal force against those burglars without even giving them a warning.
Okay, so I think that you're going to fall into another property situation since it's not your dwelling. I think it's going to fall, and I think you're going out there to prevent a forcible felony, which is the residential burglary of your neighbor. I think that residential burglary is a forcible felony. So I think you theoretically could have protection. I don't know. I think I agree with you. I don't know if I would recommend it. I think it might not be a wise exercise. Especially if you're going out there for nothing more than to confront him.
Yeah, for property, for things.
Right, to confront him. I think you might be wiser to utilize. I don't understand what your purpose would be. Just put him. I don't understand what you're going to gain by going out there to do that. But unless you're just going to, the only thing you would do is just put him on the ground and wait for the cops. I suspect.
But it is good to know that at least that if you are witnessing, if you live like in a very rural area, for example, and it's going to take quite some time for maybe the county or the sheriffs to actually arrive on scene,
right, that
you are preventing the commission of a felony, a forcible felony,
right,
in the defense of others' property.
In defense of other property, right. It's not your home, so I'm uncomfortable with giving you the right to, again, we could look at that as defense of the dwelling of other, but I'm more comfortable with giving that defense of other property analysis. And specifically because that is a forcible felony that you're observing on somebody else's property.
Mm-hmm. And I can't stress this enough, it is so insanely dangerous to give somebody who's conducting these types of crimes a warning or a notification that you're there. All right? These are people who are already willing to do the time, so you don't ever expose yourself unless you are ready to seriously engage immediately with that lethal force. Okay, you shouldn't be giving them a hands up warning. You need to be certain that that's where you need to be. You need to be certain you're falling within the law, the constraints of the law, and you need to keep yourself as safe as possible. I would even say, stay away, don't confront them.
And I think this again. I don't think this is a concealed carry scenario either. This is a defensive This is more of a use of force scenario. This is something that's outside even a concealed carry class scenario. This is more of an advanced training scenario.
So again, just be advised that if you're going to confront somebody conducting burglary on like your neighbor's home or something like that, you don't want to say, hey, get your hands up, I'm here to confront you with my firearm. You need to know what you're doing there, what your purpose is there. Don't put yourself at risk at all. And then, for the legal vernacular that we're covering here today, you used a term earlier, jury instructions.
Yes, this is the jury instructions. And when I'm talking to a jury, when I'm giving my closing arguments, I use this exact language. He is justified in the use of force, which is intended or likely to cause death or great bodily harm, only if he reasonably believes that such force is necessary to prevent the commission of a forcible felony. Again, that's in the force of other property. Reasonably believes. I use that, and then I argue the facts of the case. In the case that we were just describing, the rape on the subway car, that you reasonably believe that you had to step into her shoes to prevent the harm, the imminent bodily harm that was happening to that victim, that you stepped into her shoes to prevent her from continuing to receive that harm. That's what I would argue to that jury. The information that we're providing you is the exact law and the exact instructions that I would read to the 12 jurors that were trying you. And that's the law that you need to know, because that's the law that should guide your actions.
That's great to know. Something I was thinking of as you were just saying that is, the more people that become educated and trained and aware of, safe firearms use and, license to carry, the more empathetic of a jury you'll have and the more understanding you'll have, or they will have, of your circumstances, because they've already probably mentally rehearsed these things before.
And I that's why I agree with you as well. If we could educate society, they see so many firearms on primetime TV. They see so many firearms just day in and day out in such a negative manner that they don't know that they are a tool, that they can be used that they can have a place in society with a productive, positive role in society.
Absolutely.
That they can be used in a place to empower society. We were talking earlier about the role the AK-47 has played in the history of the world. It's been used in a lot of places to empower people. The firearm can be used for that role, and again, with education, removing fear from people and educating people, the firearm can have that place in society, and can be, and with education and experience, yes, and proper training, you can change that place in society, and you can change the role of the firearm in society. Yeah. I think you can do that as well.
And I have two things I really want to hit on. That is, for all my newer students who've never had firearms experience before, maybe they went shooting yesterday before they come to my class, I always tell them my number one goal with you, and I love every time I accomplish this, is to turn your fear into confidence. Because it's so simple. It's 4 weapon safety rules. First and foremost, you know those weapon safety rules, you don't violate those weapon safety rules, a little bit of handling training, some good basic fundamentals in the marksmanship, and your fear melts away.
And I'm also a believer in explaining to them what's happening with the firearm, the explosion within the chamber, the explosion, the projectile leaving the barrel, the spinning of it. I think if they know the physics of what's involved with the bullet, with the primer and the explosion of the gases and the gas leaving the barrel and the slide going back and it racking another round like that, I think if they know all of how the firearm works, I think that the education of everything of it, it's a very fascinating little piece of engineering.
And you learn how safe it is.
It is actually quite safe.
Like, I didn't grow up a firearms guy. I grew up over in the southwest, side of Chicago. My mother's family hunts up in Michigan, but my uncle was killed in a hunting accident when I was, I think actually the year before I was born, or maybe when I was still a young child. So my father, being raised in the city, was just not about it, right? I never was raised around firearms. Fired him a couple times, but it wasn't until I went into the military and I actually really understood the mechanics behind it all that I was like, wow, this actually makes sense to me. And when it makes sense on what it's doing and where it's going and how it's getting there, you happen to become much more educated. You know, fear usually eradicates fear. Or I mean, education usually eradicates fear.
And I'm a firm believer in education eradicating fear.
Or maybe sometimes it develops it.
Yeah,
You know, it just depends, I guess, on the topic. Let's kind of go over and talk about some common terms, descriptive terms that we hear across the United States. So, duty to retreat. Duty to retreat means that I, as the concealed carry licensee, need to do everything within my power to remove myself from a situation before I'm able to use deadly force. There's only a handful of states still that utilize this. Is that definition of it correct?
That is the correct definition of a duty to retreat, yes. Duty to retreat state.
And is Illinois a duty to retreat state?
No, Illinois is not a duty to retreat state.
So if I'm confronted with a forcible felony, you know, either in defense of, and this is something else I want to touch on really quick here also, is that I usually summarize, I call it the 4 times that you can use lethal defense in Illinois. I say in defense of yourself, in defense of others, in defense of your property and others' property. Your property kind of including that castle doctrine. How would you describe all the circumstances? Would you say there's the top 4 or 5? How would you explain that?
No, I would agree. Your defense of self, defense of others, defense of property, defense of others' properties. I would agree with. I would absolutely agree with that.
Okay, good. Just wanted to make sure I'm not misguiding anybody.
And I'm using that from the justification parts of the defensive statutes, the 5.7 statutes of the criminal code. There's actually a specific section of the affirmative defense statutes that are called the justification statutes, where I'm drawing them from, specifically from that section of the criminal code.
You're not just making it up. We're not just sitting here giving
we're not
opinion.
doing that all.
No.
There's actually a section of the code of the criminal code called the affirmative defenses sections, and we're drawing that specifically from that section.
And if you just Google, ILCS, 720430.
Actually, I've got them right here. It's 720 ILCS. Let me just see if I can find it real fast. It should be it's 720 ILCS 5/7-1 through 7-4. Should be the 7-1 is defensive person, 7-2 is defensive dwelling, 7-3 is defense of other property, and 7-4 is use of force by an aggressor. That's another interesting one we haven't discussed yet. I think we're going to talk about that a little bit later on. That's when you're the initial aggressor and you back out and things go hairy on you and you have to use force.
I actually do have a scenario designed just around that that I definitely want to touch on. And we'll include all this within like a link description. We have it on our website actually, where you can just click on what the Illinois laws are, and it'll bring you right to the Illinois compiled statutes page. It's not opinion, it's not theory. Okay, this is just coming straight from the legislation itself.
And these statutes aren't hard to read. They're pretty much cut and dry.
Yeah.
They read pretty much plain English.
Marine, if I could do it,
Exactly.
Anybody can do it. And they're not that long either. So going back to duty to retreat, Illinois is not a duty to retreat state.
It is not a duty to retreat state.
So I do not need to do everything within my power to remove myself. All I need to do is have the reasonable belief that the forcible felony is about to be conducted or is being conducted.
Well, that's also is that you have a reasonable fear for your, again, that's self-defense. You have a reasonable, great bodily harm, a reasonable fear for death or great bodily harm.
So let's talk about stand your ground states.
Okay, and again, let's talk about stand your ground, because they're more of a product of the southern states.
Okay.
And Illinois is not a stand your ground state, and what stand your ground really does is it gives you the right to pre-trial hearings where the judge has a statute where he has no discretion but has to dismiss the murder charge. Does that make sense to you when I say that?
So the way that I'm taking that is that if I am engaged in lethal self-defense and I'm arrested, and it's possible that I could be charged with murder, in those states I'm not.
Well, or you would be charged with murder, but if you assert your stand your ground rights, you're entitled to a pretrial hearing to assert if the case can go forward before it goes to a jury trial. Because let me tell you this, if you can avoid a case ever going to trial, you want that case not to go to trial.
And why is that?
Because it's just, you don't want to ever gamble with a jury. If I can win a case from a judge having to rule to dismiss a case because there's no statutory leeway on him having to rule that he has to dismiss the murder charges because the stand your ground statute requires him to dismiss the murder charge because it was a valid self-defense exercise and the statutory requirements require him to dismiss it so it never goes to a jury. That's the best situation for my clients. Does that make sense?
In stand your ground states.
In stand my ground states.
Which Illinois is not.
Which Illinois is not. And remember, Illinois, that history of not being a concealed carry state stays with us. Mm-hmm. We're not a real strong self-defense with a firearm state.
No, we're not. And so therefore, stand your ground.
Yes, I've carried some really strong self-defense. I believed in my cases for self-defense, and I've come back. The juries have second-degreed me out.
Wow.
And I'm like, how could you do that to me? It's because they just, Cook County, they're just, the jurors are, they have a hard time with it when one party pulls a firearm on another. And, in the Cook County, there's a saying among the lawyers that if there's a body in Cook County, you're going to do time, and in the cases that I've won, my clients didn't do time, even though they were found guilty. I got straight probation. That's how crazy the case was, that it was so close to being justified that the judge didn't even sentence him to probation, sentence him to jail time. But if had it happened 2 miles east of our location, he probably would have done prison time.
Interesting.
So.
And I do want to talk more about what to expect after an engagement.
But had we had a stand your ground statute, it might have never gone to trial because I might have won it on a pretrial motion. Because of the stand your ground statute, the judge may have ruled that I had the stand your ground statute, and he had no discretion but to rule that it was self-defense and dismissed the murder indictment.
And correct me if I'm wrong, but a pretrial is just simply when you, your lawyer, and the judge get together with the prosecutors to even decide if the judge wants this to even continue on.
Well, no, it's a contested motion.
Okay.
A pretrial conference is when we all get together and we do things like that, calendar stuff up, and there's nothing contested. But a stand your ground motion would be pursuant to the statute. That statute would be part of, let's say, Florida's statute. So we have in Illinois, for example, a motion to suppress evidence and quash arrest, motion to suppress evidence illegally seized. In Illinois would be a statutory motion that I would file. And then we would have a contested hearing in front of the judge. I would put on the evidence in support of my motion, and I would force the judge to rule on my motion. And if that was a stand your ground motion and I had evidence to support my motion that I believe that would support him to rule in my favor, and he ruled in my favor, then my stand your ground motion, that would never go to a jury. That murder indictment would have to be dismissed. And that murder charge would never see a jury, which is by far the best outcome.
Okay. And so in those stand your ground states, where it is relevant, that would then lead to just a lesser charge?
Technically, it depends on what you charge the client with. If you only charge him with a murder one, case dismissed, walk home.
Okay, I see what you're saying. And to be absolutely positive on what stand your ground would qualify as, that is, I have the legal right to be where I am currently located whenever the incident took place.
Correct. I have the legal right and I have no duty to back down and retreat. I have no duty to take one step backwards.
So how does stand your ground differ from a state like Illinois, where it's not duty to retreat, but it's not stand your ground?
Well, Illinois boils down to you don't have a duty to retreat, but you also can't be the initial aggressor.
Okay.
So as long as you don't have a duty to retreat, but you also you cannot be the initial aggressor in Illinois.
So in stand your ground states, if I'm the initial aggressor, I could utilize a stand your ground self-defense.
I see. That's a good question there. I don't know. I don't know if that the self-defense is available to you under a stand your ground as the initial aggressor. I know as self-defense is not available to you in Illinois as the initial aggressor. If you're the initial aggressor, again, unless you under the 7-4, the initial aggressor, you have a duty to retreat then. If you're the initial aggressor, and you have to exhaust all the means available to you prior to asserting self-defense.
So let's talk about that. So Illinois, again, is not a stand your ground state. It is not a duty to retreat state. basically just go about your day, do what you're doing, be legally able to be wherever you're able to be. And if somebody's attempting to, harm you under that definition of, forcible felony, remember, just always use your best judgment, okay? But it's not a stand your ground state, not a duty to retreat state. But let's talk about if I'm an initial aggressor. So if if somebody talks to my wife and I don't like the way they're talking to her, everybody's sober, nobody's drinking, and I go to punch a guy in the face, and then it turns out, well, he's a really great fighter. He starts getting the best of me, and I pull out my concealed carried firearm and I use it on him in lethal force. Am I the initial aggressor? Did I do everything appropriately in order to remove myself from that situation?
Well, let's see. Let's examine what the law says about that. The justification, the use of force by aggressor. The justification in the preceding section of this is not available to a person who otherwise initially provokes the use of force against himself, which would have been yourself, unless such force is so great that he reasonably believes that he is in imminent danger of death or great bodily harm, and that he has exhausted every reasonable means to escape such danger, other than to use such use of force which is likely to cause death or great bodily harm to the assailant. So you have such force is so great that he reasonably believes that he is in imminent danger of death or great bodily harm. This boxer is such a good boxer that he's going to kill you or hurt you very badly, and you've exhausted every possible means of escape. Have you exhausted every possible means of escape?
Man, he's beating me unconscious.
And then you would be justified in using. Then you would be justified again. You've got to try to retreat from that situation. That would be a situation where you had that duty to retreat.
Where I'm the provokee, where I'm the one who started the conflict to begin with. However, that doesn't necessarily give this person the right to kill me or to cause great bodily harm or disfigurement.
Or there's another scenario in which you would be authorized to use that force. In good faith, he withdraws from physical contact with the assailant and indicates clearly to the assailant that he desires to withdraw and terminate the use of force, but the assailant continues or resumes the use of force.
Okay, so for that same scenario, I happen to be the better boxer.
Right.
I hit the guy in the face, knock him down a few times, and I say, you know what? This isn't worth it. I'm sorry. I'm over this. Let's just go ahead and go our separate ways. He stands up, pride's hurt a little bit, pulls out a firearm. I engage him first. I end up killing this individual. That would be an instance to where, in good faith, I did everything I could to remove myself, even though I initially initiated it.
That's correct. That's correct. You initiated, you tried to withdraw yourself, but then he re-engaged you with deadly force. That was a justifiable shoot.
Okay. See, and these are, without diving too far into these scenarios,
because these are a little bit. You're getting into a little bit more of a mix here. You're getting into a little bit more variables into the equation here.
And I'm doing that, increasing in the complexity, and you're doing so awesome and answering all these questions exactly how I would hope that they would have been answered, because you could what if anything all day. Exactly.
And again, what we're doing here is we're answering these scenarios, but more importantly, I'm giving you a statutory basis to, if they're like, we're throwing these at you real fast, but there is answers for you. If you're giving them too fast here today, go to these statutes and just break down these statutes. These statutes, they're not long. They can be broken down, but the answers are there. And they can, if we're going through them too quick for you today, just go back and look over these answers. Read them slow. Read them slow, and they make complete sense.
Yes, absolutely. Or challenge your instructors as well into these, the formality of these legalities. Because these are the things that are going to cause you confusion and fear and hesitance whenever it comes to defend yourself.
Yes, I agree with that.
Let's talk about, let's see, we said Castle Doctrine, Illinois is, but it has a little bit of caveat.
And I want to say a qualified Castle Doctrine.
We have Illinois is not a duty to retreat, and it is not a stand your ground state.
And the reason for that is I agree. Stand your ground just gives you a little bit more protection with the pretrial ways to avoid that. Again, yeah, I just that's my opinion on that. We still have a lot. We just don't have the pretrial protections that Stand Your Ground offer.
And I wouldn't see them coming to Illinois anytime soon.
They're not coming. No. They're not coming. They are not coming to Illinois.
It's very unlikely we'll receive more leniency.
And I agree with that.
Yeah.
I absolutely agree with that.
So let's talk about a couple of things in regard to handguns, and then I want to dive into some of the scenarios that we developed.
Absolutely.
So, a handgun, why can we see short-barreled rifles technically be classified as a handgun? How does that work?
Are you talking about short-barreled rifles, for example? We classify a short-barreled rifle as the 9.5-inch barrel with the brace. Is that what you're talking about?
Yes.
Okay, with the brace.
With the forearm brace, not a buttstock.
Not with no buttstock is what I'm calling the short-barreled rifle. Okay, without a buttstock.
So how do our users know if it's a handgun then, or if it's a buttstock? Because they look pretty similar.
They do look pretty simple. I think you're gonna have to. I think you're gonna use the distinction by. You're gonna use the distinction by the brace. I think the only way, because I think it looks so similar. Is the brace is going to be how you're going to distinguish it. Is the only way you're going to be able to distinguish it. In Illinois, the only way you're going to be able to distinguish that is by the brace.
Okay.
You agree with? I think you would have to agree with that.
Yeah, and it is hard to the untrained eye because a brace does resemble a buttstock.
It does resemble a buttstock very closely, but you got to have that. That strap is the only thing the only distinguishing characteristic, if you ask me.
And it goes back to just being educated and trained properly on what it is that you're dealing with.
But that's a dangerous situation because I have a carbine with a 9.5-inch barrel, but I also have a 5.5-inch flash suppressor on it to break it to the minimum 16-inch length.
So the flash suppressor, which for some of our users who may be newer to firearm usage, is going to be an extension. A piece of metal that is either screwed or welded into the end of the barrel.
Mine is welded in because it also has to have a permanent top side. It also has the permanent front sight attached to it for it to be legal in Illinois.
So in that case, that flash suppressor, because whenever you release whenever the round leaves the barrel, the explosion of the gunpowder primer and the force that is exerting that round through the barrel and down towards your target, that fire, that explosion, that light needs to go somewhere, and it comes out the front of the barrel. So when you have a flash suppressor, what that does is it disperses that explosive force, the visual of that explosive force a little bit, so then that way it's not as obvious as to where it's coming from. But in those cases, that welded on flash suppressor will also include as a barrel extension.
That's correct, and that's considered a 16-inch barrel, which makes the legal requirements in Illinois, as long as it also includes a front sight, a front post.
Okay, so there is a difference between AR-style platform rifles and AR-style platform handguns in the state of Illinois. Make sure you're just asking plenty of questions. If you see a buttstock that looks a little similar with a piece of a Velcro strap on it, ask the dealer if that is a handgun.
And be careful about SBRs because they are really subject to being scrutinized by the ATF right now. And I would not be surprised to see them come under additional ATF scrutiny within the next couple of years.
And what qualifies again for a short barrel rifle?
The short barrel is 9.5-inch barrel and the brace, the arm brace in the back. A lot of that's coming under scrutiny because they want to make that just a tube in the back, not that brace in the back.
Okay, interesting.
And if you've ever seen them, have you ever watched anybody shoot one? Have you ever shot one?
Oh yeah, plenty of times.
I'm not a fan of them.
I am not a fan of not having anything at all. That's for sure. Like the tube in
Right.
the end, that just doesn't make any sense to me at all.
It doesn't make any sense to me at all.
That's actually like it's also ironic that that's like what legislators push for, because anybody who's using that then now becomes so much more of a hazard.
That's what my I think. Without that, I think it's again. I find them to have no value whatsoever.
No, it just is creating erratic shock groups,
exactly
putting everybody else at risk.
It's a danger to everybody else on the range.
So for firearms, what happens if my gun is stolen?
Now, I looked at that up in a statute. You have 72 hours to report that firearm stolen. I provided you a statute on that. Report of lost or stolen firearms. Within 72 hours after obtaining knowledge of the lost or theft, you must report it to a law enforcement agency. And if you don't report it, you can be guilty of a petty offense for the first violation. Second one is a Class A misdemeanor.
What if I don't report it and it's used in a crime like a murder?
I see. I didn't find any violations for that, but I do think that theoretically, if you don't report it, that theoretically could be. You're going to most certainly face some scrutiny for that.
What if I don't notice it's missing?
Then again, it has a knowledge requirement. After obtaining knowledge, there is a knowledge requirement. We do have a number of mental states in Illinois. We have absolute liability, which is what's required for a speeding ticket. They don't care if you know you're speeding or not.
Mm-hmm.
Then we have what's called absolute. We have negligence. Then we have gross negligence. Then we have knowledge, and then we have intent. So what you're looking at, just so you know, knowledge is when you knowingly do something, and intent's when you intend it. Negligence and gross negligence are just that.
Accidents.
Exactly. And severe act, you know you're causing an accident.
Yeah.
But knowledge is one of those when it's knowingly. I know when I'm doing something.
So if you have a firearm and the moment that you find out that it is actually missing from your possession and stolen, you have 72 hours to report that to local law enforcement.
And failure to do so is a petty offense, the first offense. What's a petty offense is just a fine of $500 or $1,500, excuse me. Second one is a Class A misdemeanor.
And, which just highlights the point, be responsible, lock up your firearm. Sometimes it does happen, though. Your guns may get stolen from you. Maybe you work in an industry with firearms and you leave one or two of them unsecured in particular areas and they get stolen in a vehicle. Just make sure you're doing the right thing, follow on, swallow your pride, report it to the police missing. You don't want to be held liable for something that was used against somebody in a violent manner, that's for sure. All right, so that kind of brings us here to the scenario-based portion, which I think everybody is most excited for, because this is, again, this is the most baseline types of scenarios I've drawn up. We could what if the scenario to death, but always make sure that you understand your legal rights, make sure that you understand what you're able to do, not to do, where you're able to do it, not able to do it, and always use your best judgment, okay? Remember, it's never going to be an easy, it's never going to be an easy task taking somebody's life. And odds are, in SOCOM, they did a study, the Special Operations Command, where after putting us through stress tests, like to get our heart rate up to about 160 some beats per minute, to simulate combat, because you can't test accuracy, in combat. Operators were shooting at 33.33% efficacy when their heart rate was above 160 beats per minute. So if that is a Special Operations Navy SEAL, MARSOC Raider, Green Beret, what does that tell you about the ordinary person walking around with a concealed firearm in times of high stress? You're going to be much closer to that, but my point in all this is that when you decide to pull that trigger, you don't think about hitting them in the chin. You don't think about the sounds that person's going to make. You don't think about watching the life leave their body. It's always going to be a rough, scenario, a rough situation for you. However, they took that choice away from you when they decided to commit whatever violent or heinous act upon you that they did. It's just life sometimes. They took the choice away from you. You need to defend yourself. And so therefore, always use your best judgment. Always think through things as much as you possibly can before actually doing it. Would you agree with that or have
Absolutely.
anything more?
Yes, thinking. A thinking concealed carry license holder is the best concealed carry license holder.
So let's get into the first situation then. So here we're going to talk about road rage. So let's say that I'm driving on the highway with my 8-month-old, or my 8-month-old, not year old. Okay. He's in the back seat. It's Thursday evening, about 6 p.m. So end of rush hour traffic. I see somebody coming up from behind me, very fast, driving erratically. They reach my tail, they start honking the horn, flashing lights at me, they're being belligerent. I'm already going 10 over in the right lane. I'm doing my thing, I'm not being belligerent back. They start pulling up to me, I start keep honking, right? And I'm getting agitated. So I brake check them a little bit. The brake check causes them to tap my vehicle. They pull around to the side of me, start throwing items at my car. I pull out my firearm and I engage them. How do you see that going for
when you say engage them? Are you throwing lead? Are you?
I shoot. Yes, thank you. I shoot and I end up killing the passenger and wounding the driver.
Now? I have a problem with that scenario. I have a problem with that discharge of that firearm. Do you feel that when they came up to the side of the vehicle and they threw trash at the vehicle? Do you feel that placed you in a situation where you felt that you were at risk of death or great bodily harm reasonably?
Well, as a defendant, I'm going to definitely say yes.
Right.
But for the purpose of the scenario, we'll say that he was not.
Okay, at that point, let's dissect this scenario. Let's dissect this scenario, okay? You've got your son in the back seat of the car.
Mm-hmm.
You've just discharged your firearm from inside the car.
Mm-hmm.
Let's say you rolled down the passenger side window first, so you didn't shoot through the window. You've discharged this firearm on a Chicagoland highway.
Yep, we'll just say it's I-90.
We're going to say it's on I-90. And you struck the individual at least?
I killed the passenger, wounded the driver.
Killed the passenger and wounded the driver. And that vehicle was going how fast when it
65 and a 55.
And did it strike any other cars when it?
Nope, I didn't even know that I had killed them or wounded them until I was arrested later on.
And what happened to their car after you hit them? Did it roll to a stop, or did
we both got off on different exits?
You didn't kill them instantly?
The passenger, yes, but the driver was still alive.
Okay, so he was able to pull the car safely off?
Yes.
Okay. So the question that you're going to face at that point by the prosecutor's office is, were you justified in the use of deadly force? They bumped your car, and they came up and they threw trash at you. And then the prosecutor's office is going to say, did the act of them throwing trash at you, did that warrant a reasonable person to be in fear of death or great bodily harm at the time you fired the shots? And as a defense attorney, I am most certainly going to assert self-defense, that your fear from after you were bumped, you were afraid that the person was going to come up in front of you, and that they were again going to strike your vehicle. That was going to cause the car to swerve out of control, causing death or great bodily harm to both occupants of your vehicle. That was your fear, and you were trying to prevent that from happening. That's the argument I'm going to make. I'm going to say by you put yourself in a dangerous position.
Mm-hmm.
I'm going to tell you that right now. I'm going to tell you that you're probably looking at a second-degree conviction.
And there's a couple of key points that I like to think about in this scenario here specifically. One, I have my child with me, so I don't ever want to use a firearm, especially in a vehicle.
You've just really hurt that child. You've done some damage to that child, permanent damage to that child's hearing.
And unless I am, without a reasonable doubt, 100% certain that they're about to do something, or I see them about to do something.
I think you snapped off a little early on those shots.
And they do in this scenario. The other thing is that I brake check them, which causes them to hit me.
Exactly. Were you the initial aggressor?
And, I think that there's a lot to be said about that brake check thing right there, because I put my son in more danger there, I think, than they did in this whole situation. Are they being assholes on the road? Absolutely. But the brake check causing that physical contact, I would expect the response of them coming up and throwing trash at me, perhaps. But then to just shoot and then end up killing somebody over this situation, I think it's a lot of unnecessary action. A
lot of escalation.
Yeah.
Now again, I don't want to say. That's why I said second degree. I don't want to say that you were completely unjustified in your actions, but I think you're losing.
Yeah, it's an uphill battle.
It's an uphill battle, but I think you're losing under that scenario. And listen, this is what we have to talk about. This is why you need this education and this training. I just said you're losing. Does that make sense to you?
Yeah, absolutely.
I just said you're losing. And I'm talking about Cook County. I'm talking about Illinois juries. This is not Georgia.
No.
This is not Florida. You are not getting you're not getting a damn right. You're not getting a better to be tried by 12 carried by 6 mentality up here.
No.
You're getting this is an entire population up here that looks at guns sideways.
Yep.
And looks at shooters sideways, and you need to remember that.
And now you're contributing to their warped
now you're contributing
perception.
to the reason they don't like guns in the first place.
Absolutely.
So please remember the societal mindset that you're beginning with.
Even though Illinois is not a duty to retreat state, I always encourage my students to avoid and de-escalate situations.
And I think de-escalation is a wise practice to teach.
No one's life's going to be the same the moment you pull that trigger.
And especially yours, especially the trigger puller. Remember that as well. You're gonna remember that's gonna scar you as well. You're gonna remember that. You're gonna be sleeping with that the rest of your life as well. So please.
And that's one of the most important things I tell my students also, when it's like, how will I know I'm ready to engage? You'll know because you have no other choice. And that's when they take the choice away from you. It probably still won't be an easy walk in the park. I talk a lot about psychological recovery, emotional recovery, if you're ever involved in an incident, and saying it's okay to seek help. However, there's a difference from the situation where I'm choosing.
You'll sleep a lot better when you had no other choice.
No other choice whatsoever.
You'll sleep a lot better.
So, in conjunction with road rage, let's talk about a highway shooting incident. Okay. So, it's Tuesday morning at 9 a.m., and the I-90 traffic comes to a sudden dead stop. I start to hear gunfire in the traffic ahead. I witness 4 men in total, 2 separate groups, shooting at each other over the vehicles that are now parked on the highway, running towards me while they're shooting at each other. I decide that for the safety of others who they're shooting over, and for the safety of myself whom they're coming towards while shooting, I get out of my vehicle, I engage the 2 assailants on my side of the shoulder, and I end up killing both of them. The other 2 on the other side run away, go to their vehicle, and they drive off.
Okay. Defense of self or defense of others?
Well, I would think both, couldn't it technically be?
Were you a target of the gunfire?
I could have been indirect target, like a bystander.
Defense of others. I think that's a justified shoot too. They shouldn't have been throwing lead down 9 or 890 in the middle of traffic.
And this is a real scenario that happened back in 2021, minus the concealed carry holder. No concealed carry holder existed.
Right. I think because of them throwing lead across traffic, I think if you can stop that scenario, just because of people in those lanes of traffic subject to the crossfire, I think you putting an end to that scenario would be a justified shoot.
I agree to that as well. The one thing that I always want to tell people, though, all my students especially, is that when you make that choice to defend others, okay, one, you need to know what you're getting into, because who's to say that those aren't undercover cops on your side of the road?
Right, exactly. And you remember, you're going into a 2-on-1 scenario. You just, once you pop up, you better be able to take 2 out. You better be able to win the fight you just entered.
And you had better be willing to lay down your life for the benefit of the others around you.
Exactly.
So in defense of yourself, if you feel, oh man, there's bullets flying everywhere, I need to do this to keep myself safe, or maybe your family or loved ones with you, of course you're justified. If you even want to do it to keep everybody else safe, because again, that's what it's about, helping one another, just know the situation as best as you can, and just be ready to make that sacrifice. But I would always recommend that actively making that sacrifice, or potentially making that sacrifice, is always much greater than just sitting there and then becoming a victim, and you could have done something. But always know what you're getting into as much as you can prior to actually engaging anybody. Our next situation, I'm out at a local bar. It's Saturday night, and I'm drinking some beers with my friends to celebrate the week. We visit this place all the time. I live down the street. I walk home here every week, every Saturday. Random group of people come in. They're highly belligerent, harassing the locals, smashing drinks on the floor. One of them takes a glass, throws it against the wall next to my face. I say, you know what? We're going outside. We're going to fight. We go outside. We end up fighting. I end up getting the better of this person. He stands up, pulls out his firearm on me. I engage him first with my firearm. Keep in mind, though, I've been drinking quite a bit. And I end up killing this individual. What is somebody in that scenario to expect?
Again, you engage in the physical altercation, which was a mutual combat. So there's nothing there, and then you disengaged. You withdrew from that, and then he re-engaged you with an escalation into deadly force. You feared for your life, or great bodily harm. I think you were justified in that shoot as well. You were outside the bar, so you were legally carrying. So let's just say that you had an opportunity to return to your car and pick up your weapon before the fight. Just give me that scenario as well. So you were legally carrying your firearm. You had your physical confrontation. You were manly or whatever. Your unarmed combat. You had done that, and now you had disengaged from that. But he wasn't happy with that, and now he wants to engage you and pulls out the firearm, and you just beat him to the draw. Justifiable shoot.
How does me being under the influence of alcohol affect this situation?
All that's going to do is determine whether it's reasonable or not. Are you still reasonable in your interpretation of events?
And as long as I am, and I'm not...
As long as it's reasonable. Again, like I said, you could blow bong smoke in his face. As long as your interpretation of events is reasonable.
Interesting. Yeah, because that's something, too, that I've always veered away from with my students is that,
I'm not encouraging anybody to mix margarita, to pop
blow bongs and
to blow bong hits in anybody's face. But I'm just saying, if your actions are reasonable, they're going to be reasonable.
I just always assumed that Illinois would say, "Nope, alcohol, you're done."
But what you're going to run into is the real life experiences that alcohol usually leads to unreasonable actions.
Absolutely.
So it's usually not even a frigging question about reasonable or unreasonable, because it's so far grossly unreasonable because of the presence of alcohol that we don't even get into this discussion.
Yeah, that's a great point, and which is why we say if you're going to drink,
you leave your gun at home.
Absolutely.
So that's why you usually don't have to even get into a question about, we can say this. So if it is, that's why you usually never hear a question about alcohol when it's such a reasonable shoot. Does that make sense to you?
Yeah.
Because we don't know if their BAC could be 1.6 or 1.7. They could be a maintenance alcoholic, and you never hear about that question because it was a reasonable shoot. So they never got to question 2. What was their BAC?
Yeah.
Does that make sense to you?
Yeah, absolutely. That's actually a really good point. Something that I wouldn't have thought about before. All right, attempted home invasion.
Okay, so they never make it through the door, correct?
No, they do not.
Okay.
So it's 3 a.m. and my camera system picks up 2 people. It's summertime, my windows are open, I got screens.
Okay.
My camera system picks up 2 people. It looks like they're looking into my 12-year-old daughter's room.
Okay.
She's not home.
Okay.
I grab my AR-15 style weapon. Now this is a self-defense, right? More than a concealed carry.
Okay.
Grab my AR-15 style rifle.
Okay.
And from down my hallway, I take aim at the window that I see them attempting to break into.
Okay.
I'm concerned that there's 2 of them, and they're looking for my daughter's room, so I have no idea what these people are up to.
Okay.
As soon as I watch the screen pop off my window,
okay,
I engage and I kill the one.
Okay.
The other one gets away unharmed.
Okay. They hadn't broke. With just the mere act of breaking the screen off the window, I don't think they had gone far enough.
They haven't crossed the threshold.
They haven't crossed the threshold of the house. I think you exposed yourself to liability for that.
Interesting.
Now, Texas, I know there had been a recent case in Texas, and Texas is a lot different in their castle doctrine than we are in Illinois.
I think everybody is aware, yeah.
And I think in Illinois, without them crossing that threshold, you could be exposing yourself to liability. Texas, you might not be, but Illinois, I think with our castle doctrine in Illinois, without them crossing that threshold, I think you're just going you're a little bit too early.
So then, what about like a burglary? Like if I thought they were going to commit burglary.
Now again, a burglary is listed in that forcible felony. A burglary, they're coming in for a burglary. A burglary is a residential burglary is listed in that forcible felony statute. Even though your daughter's not in the room, that's really not relevant. They're coming in. They're taking that off once they cross that threshold. I thought they were coming in to commit a burglary
or a sexual assault, perhaps.
My wife or me.
Yes, absolutely.
I thought they were coming in to commit a forcible felony.
So it's just important to know that you're opening yourself up to some sense of liability. But it's not cut and dry. None of these situations, well, some of them will be, but sometimes there's some gray area. You just need to always be using your best judgment.
Yeah, exactly. It's just letting them pop the screen off. You just jumped the gun. Forgive me. That's a training scenario. That's an education scenario. You don't know what they were going to do next. What if just walking up to the door and racking, or just charging that AR might have just been enough to send them running. Does that make sense?
Yeah, one of the best home defense mechanisms.
It's just racking a shotgun.
The sound of a shotgun, cocking back. My wife knows. She goes pushing the button, and if they don't go away, keep it pointed at the door.
That's exactly correct. So that might have been all you had to do in that scenario. So that's my concern with that. And that's what I think you're going to get a prosecutor's office say. You jumped the gun on that.
That's good information. Let's talk about
Whereas if they're inside the house,
now they've crossed that threshold.
Now you don't have an argument that you jumped the gun.
Yeah, that's well beyond. And again, they could have been a couple of buddies breaking into a friend's house.
Thought they were invited to the young lady's room, or we're in the wrong house, and you don't want that.
Which that actually brings up. I didn't even put that in there on purpose, but the totality of the situation,
right?
You've got to know, and now
you don't want to be responsible for.
No,
you don't want that on your conscience.
No, nobody does.
Exactly.
Not at all.
And again, this goes back to what we were saying early. You have to live with the decisions. You're putting an instrument in your hand that has the possibility for taking human life, and you're taking the responsibility to be a licensed holder with that responsibility. You're taking the training and the education for that responsibility. Take it seriously. Take that responsibility like what we're giving you is the ability to take that life. Take it seriously and get the appropriate training and take it seriously so you don't make the mistake, so you don't live with that guilt for the rest of your life. Get the classes so you just have what's called trigger discipline. When you have that trigger discipline, it's going to be a hell of a lot easier to go back to bed and say, thank God I didn't pull the trigger in that scenario. It's just a bunch of stupid kids, than it is sitting up the rest of the night going, my God, I wish I'd never pulled that trigger. It's just trigger discipline is so important. And I'm just begging that you think about that more so than being so happy about your new Glock 40. Trigger discipline is what I want you to be more important. It's what I want you to be happy about. Developing trigger discipline is what I wish you'd be more happy about.
And training is fun.
Training is fun.
Yeah.
When you start working about, it gets to be fun when you start working on scenarios where did I get the right guy and not get the wrong guy? Does that make sense? That's when you're starting to be on your mental game, and that's when you go through those scenarios and that training where you start to do that. When you hit the houses, the shoot houses and stuff, it really is fun going through those houses and not hitting the wrong people.
Yep.
So please, this training is fun. And it really works on your mental prowess. It really makes you on your game.
Yep.
It does give you a sense of self. And I encourage you to engage in that. It'll make you. It'll give you a sense of pride. It'll give you a sense of security in yourself. It just gives you a sense of confidence.
And I always tell my students, developing a new skill is like walking through an untamed forest for the first time. Within our brains, we're developing these neurological pathways. And if you do something once, like a concealed carry course, when you come back, you might see the footpath you did. But when you go 100 times, then you take an RV, then you take a truck, and now you've got this good, solid road that you can drive semis down. That's really when you resort to the greatest level of training you receive. That's when you do great within those times of high stress.
I agree. You've got to train this to the point of muscle memory. You've got to train this to the point of neurological pathways that are completely and unequivocally established. This is until you put 5,000 rounds through your firearms, you're not at the point where you should be even comfortable about these scenarios.
And again, it's fun shooting.
It is a great time. Don't invest again. Go online, get your ammunition, find a good course, find a good instructor, get a speed loader, load up, and spend your time putting with your firearm, putting rounds through that firearm downrange in a good course.
It'll change your life.
It will change your life.
All right, last scenario is going to be, the last two scenarios. A carjacking. We've talked about this a little bit already. So if somebody comes up to my vehicle and they open my door and they attempt to start ripping me out, do I need to verify that they have a firearm before I use lethal self-defense?
At that point, especially in this day and age with the press cycle, which we know that we have a rash we have a rash of these going on right now. I would feel that it's a forcible felony. Carjackings are a forcible felony. You come up to me right now, you open my door in my car, and you start pulling me out. At that point, I fear for death or great bodily harm is going to happen to me.
And it happens so quick.
It's so quick. No, I think at that point that the thought that's going to go through my mind is I'm being a forcible felony is occurring to me, and I have every right in the world to stop that forcible felony to me. And I think at that point, I don't think that's an unreasonable exercise of force. I don't think that's an unreasonable thought process to go through my mind.
If somebody is grabbing me in a violent way, I'm more concerned that I'm already stabbed.
Exactly, and there's people in Chicago that this has happened to twice.
Yeah.
What's the statistical probability of that happening?
Yeah.
It's even changed the way I carry in Chicago. I carry under my thigh now. It's right there.
Yeah.
It used to be here, but now it's even closer. It's right there.
Because as long as you're concealing it from public view, or it's partially concealed, imprinted in your clothing or something, or maybe you're reaching for groceries.
Yep.
As long as you're attempting to conceal that firearm from public view, then it's a concealed carry. And as long as you're licensed to do so, you're within your legal right.
That's exactly correct. So it's changed the way even I carry when I'm down in Chicago. Now, I have that readily available, readily deployable. Not just readily available, readily deployable.
The rap artist 50 Cent, he gives an interview about when he was shot. He was shot 9 times and he was a drug dealer. And he talks about how when he was being shot, he tried to pull out his firearm. He wasn't legally carrying, from what I know. But from the interview that he gave, he said that 2 things. One, he went to load his firearm because he didn't have a round in the chamber.
I always have a round in the chamber.
And 2, it wasn't in a place easy for him to reach. So as he pulled his firearm out, about the 5th time he got shot, when his hand got shot, the firearm shot out of his hand. And by the grace of, God or whomever, he survived 9 bullet wounds. But it's just such a great point that you need to have it readily. But you can't have candy bar wrappers sitting over in the center console, okay? That's a great way to get yourself hurt.
Exactly. It's got to be functional. It's got to be ready to go, ready to operate.
Absolutely. So our last scenario that I want to talk about is going to be you're at a mall.
Okay.
And all of a sudden you start to hear something that sounds like gunfire.
Active shooter scenario.
Active shooter scenario. People are running. You're kind of in a back corner of the mall, so not the easiest place to get out. Plus the crowd. It seems like the shooter might even be, on the other side of this little crowd that's running towards you. You're with your family. You draw your concealed firearm because you're ready to use it in this moment. You look over to your right, and right there walking up the steps, you see a grown man with an AR-15 or an AK-style rifle. You shoot him, you kill him. What are your thoughts?
I think at that time you must immediately place your weapon down and place your firearm on the ground immediately. Because if there's going to be a police response, they're going to shoot anybody who has a firearm in their hands at that time. You can't leave your weapon there, but you got to get as far away from that weapon as possible. Mm-hmm. I think the police aren't well enough trained to distinguish between good guy and bad guy at that point, unless you're wearing blue or police or something identifying as you police. If you have that firearm in your hand, you're a dead man.
Yeah, because they're just responding to an active shooter.
They're responding to an active shooter, and anybody who has a gun in there without a police uniform is going to be dead.
Afterwards,
I commend you on stopping the situation, but Colorado answered that question for all concealed carry license holder. The police aren't qualified to distinguish between a CCL helping them and an active shooter killing people.
And who is?
And I'm not faulting the police for that.
Yeah.
I'm trying to keep good people alive. You've done what you needed to do. You stopped that situation. Congratulations. Don't get too far from your handgun unless somebody else is helping him, and you need to do it again. But you need to make sure that you don't end up dead too. And in order to do that, put your handgun down and take a few steps away from it.
Yeah, it's important. Once the threat is neutralized, because as unfortunately a citizen found out in a Walmart shooting, there were 2 people involved.
Okay.
And when he went to engage the initial shooter, his wife was right behind him, and she killed him.
Okay.
So always, once that threat is neutralized, that was a great point that you brought up, that's when you need to prepare yourself for that law enforcement response best as you can. And that really goes for any law enforcement response in any of these situations. Don't be standing there holding your gun in your hand as law enforcement pulls up. We all know what to do to appear passive. Have it on the ground. Put your hands up. Don't sit there worry about manipulating it. Just put it on the ground, hands up, shut up, and listen to what they got to say.
Don't worry about the slide. Don't take the clip out. Just lay it on the ground and back away from it.
Because they don't know who you are.
They don't know who you are. They don't know what you're doing. You're not one of theirs. Just back away. Don't give them a reason to shoot you. They will shoot and ask questions later in that scenario.
Which actually, one thing I forgot, Duty to inform law enforcement officers. If I'm pulled over, do I need to tell Illinois cop that I have a gun on me?
Technically, you don't have a duty to inform. You do it. They will ask you, but I think it's always wiser to try to cooperate with them. Keep your hands at 10 and 9 and 3. Make sure your hands are on the steering wheel, and let them know that you have one in the vehicle.
But if they ask me,
yes, if they ask you, you have a duty to tell them. You have a duty to let them know.
So a little thing that I kind of missed earlier. Sorry about that. But Illinois is not a duty to inform state unless you are inquired with by the law enforcement officer, and they're going to know it's registered to your DMV records.
It's right on your driver's license.
You don't mess around with that. Have some empathy for these police officers and what they're dealing with.
I'm very, very emphatic about that 9 and 3. Don't make it worse. That's already going to be bad enough for you when you're keep him at 9 and 3 until you make him comfortable.
The scenario I always give to my students is if a police officer tells you, hand me your firearm, and you reach for that firearm, you don't know what his partner on the other side of that vehicle with traffic is seeing or hearing. Just ask them kindly, officer, I would really appreciate it if you would just completely take control of this situation. I don't want to reach for that firearm.
I would feel uncomfortable with that too, man.
Yeah, no way.
I'd be like, dude, you need to, it's in the glove compartment. You're more than welcome to go around and grab it, but you're handing it to him. That's just, he could shoot you and call that a justified shoot at that point.
I had a buddy in North Carolina who the cop was screaming at him, saying he was going to shoot him if he didn't hand him his firearm, and he just sat there completely complacent, completely passive, saying, please, for the love of God, take control of the situation. When his sergeant got there, he handled the situation, reprimanded the officer, thanked my buddy. So no matter what, don't reach for your firearm, no matter what the cops are asking for.
I think that's poor police training.
It was horrible. It was horrible.
I agree with that 100%. He had no business asking somebody to hand him a firearm.
That is bad methods. So a couple of final questions here for you for this evening, okay? Insurance. How do you feel about concealed carry or self-defense insurance?
I'm a strong supporter for concealed carry insurance. I hugely support people having concealed carry insurance.
How much does legal fees cost if you're, wrongfully imprisoned?
Well, one, there's bail, and bail is usually between $25,000 and $75,000. Most concealed carry people are good, law-abiding citizens. Most of them are a little bit older and stuff. But the last one that I had bail was $250,000. You had to put 10% down in Illinois. That was after it was started at $750,000. I did a motion to reduce bail and got it reduced down to $250,000, and he had to post $25,000 bail. So average is about that, between $25,000 and $50,000 bail has to be posted.
Yeah.
Attorney fees are between $25,000 and $50,000 for an attorney fees. Then there's expert fees. A use of force experts can be, you're talking about between, you're gonna be out of pocket around you're looking between $50,000 and $150,000, and that insurance can come in incredibly handy.
Absolutely.
For those purposes.
And there are quite a few different ones out there. I know there's a couple really popular ones, but make sure you do your research and you know what you're getting into, because there's caveats to all of this. You need to be within the guides of or the guidance of that policy.
Right, exactly. And they'll have their own attorney networks and things like that. But I just think for the money that you spend for that annually, it would be, if it were to, God forbid it were to ever happen, I just think you'd be incredibly happy. Just $200
to $500 a year.
Yeah, just to have it. It would just be a smart investment.
Do you think that things in society here in Illinois specifically are getting better or worse or unaffected by the concealed carry laws we currently see?
I've been surprised. I think they've been I'd like to say they've been getting better, but I really think it's been unaffected. I think since 2014 that we have had. I've been happy with the concealed carry laws, but I've been the biggest remarks I would have is that it's been so little change. We have seen positive effects. We have seen that the concealed carry license holders have taken back some of their personal dignity, have been empowered by concealed carry, but in reality, that hasn't been a revolution. It hasn't been a huge change on this, which is good, which is really, really good in many ways. There hasn't been a marked change on people doing stupid things with handguns. Does that make sense?
Yep.
But there also hasn't been there hasn't been a marked increase in gun violence, stupid gun violence. There hasn't been a marked increase in suicides by gun. There hasn't been a marked increase in poor gun ownership, like negligent discharges. There hasn't been a marked increase in negligent discharge with children and things like that. So what I'm saying is, for the last 8 years, where you've seen handguns come into society, i.e., make now legally present within society with some sort of government regulation and control, they've moved into society without them having a large negative effect on society. And I think that's been the most positive thing. I was very worried that they were going to come out and the next thing you knew, we were going to have a whole bunch of concealed carry license holder shooters that were bad shoots. And that hasn't happened. That's been ideal. I think the positive shoots that have happened, there haven't been as many as I thought there would be, and I think that's a good thing as well, because that hasn't drawn. I think if there were overnight an incredible amount of shoots, people would be like, that doesn't make sense either as well. Does that make sense to you?
Well, the big thing is too is that when you take a proper concealed carry course, you become more situationally aware and you become more able to just de-escalate situations across the board, because you don't want to go there.
And I think that is the case as well. And I think that's a good thing for the concealed carry license. If it's going to teach de-escalation before further arming yourself, then again, I'm all for that.
And unfortunately, we don't have statistics on the amount of situations de-escalated.
And I agree with that. But again, you said and I think that's been a positive thing. I think people are taking it a little bit more responsibly. And like you said, part of the goal of your organization is you see that as a goal of your organization, that we can train people for that to be a positive goal, that I can give that training to people, they can have that training, and as a result of that training, interactions with firearms can result in less negative interactions.
Absolutely.
But more positive trainings, more positive interactions, not only specifically with the concealed carry training, but more after training with that concealed carry training. And I think we're taking baby steps along that path, but we are on that path.
Yeah, I really crazy statistics, and I'll throw them in the website and the link just so I don't mess up the name of the studies that were conducted. But on average, and it's not easy to find concealed carry self-defense studies. They're pretty rare. But on average, firearms specifically, were used over 200,000 times a year by women in the prevention of sexual assault across the country. In all recorded cases of gun use, over 80% of recorded gun use cases in the United States of America are in self-defense. That's insane.
And that's a statistic that's not properly used then. What that tells me then is you're not properly using that statistic. That statistic is the foundation, should be the foundation for every concealed carry instructor as the foundation for his education, to educate a society to say that these weapons are being used for their primary purpose to protect people, and that they are being used for a fundamental tool of self-preservation and self-protection, and that they are being used in a manner consistent with protection of life. And to not get that message out is just wrong messaging.
Yeah, it's a huge injustice.
It's a huge injustice. It's an injustice to everybody out there still looking for some type of protection for against those things.
Against sexual assault. That's over 6,000 times a day.
Exactly. You don't have to carry a 45. You don't have to carry a 40. You don't have to carry a 10 millimeter. You can find something that you're comfortable with, that you can carry. That's something that's protection for you.
Yeah, smaller doesn't mean better for concealed carry.
Right. That's exactly. Or bigger doesn't mean better for concealed carry. It doesn't mean. You got to find something that you're comfortable with. That you can go down to a 22. And still have protection with
Absolutely.
The concealed carry.
You shoot somebody, no matter what, most of the time in self-preservation, we're going to run away because we don't want to die.
That's exactly correct. A small J-frame is a wonderful little concealed carry firearm. I think that with the messaging and with the protections that it can offer, if you do that correctly, then you can appeal to a large segment of the population where, I mean, we hear so much about the negative publicity of firearms and things like that, and that gets the messaging, that gets the publicity, that gets the press.
Yeah, unfortunately, to find out that over 80% of all recorded firearms uses were that in keeping an innocent civilian from being victimized blew my mind.
Right.
And I think Ukraine right now is just such a prime example, because you have a peaceful nation where people are not armed.
And they are stopping the second or third most powerful army on the face of the earth
by arming their citizens and coming together
in a guerrilla-style warfare.
I mean,
and then it's just local neighborhoods that are stopping the third most powerful army in the face of the earth.
Because the choice is taken from us after a certain threshold, and when people band together and unite and have the ability to defend themselves against that same use of force, amazing things can really happen.
Yeah, exactly.
So my last question for you for tonight, and I'm sure there's probably so many more things I'm going to think of after this, meeting here today. But from what you see and how you've seen the programs grow and the legislation since it's been accepted and passed, what can we do? What can someone like me do as an avid instructor? What can I do? What could we do to make this program better?
There's two components that I'd like to see for the let's take it from the perspective of the student, and let's take it from the perspective of a first-time gun purchaser let's look at it from the perspective of a citizen who's thinking about purchasing a gun for the first time, not from the perspective of somebody who has an experience with gun. I'm a Plainfield resident who's decided it's time for me to purchase a firearm to protect myself and my family. I've decided to enter the firearms for self-protection. It's that time. And last year was a huge for firearm sale. What can we do? What can you do as a concealed carry licensed instructor and also other firearm services instructor to make that person not only comfortable, but as a lawyer, can make him reasonably not a liability to himself and society with that firearm? What can you do for him? Okay, and also as a lawyer, what can you do for me to give me a decent client that I can ensure that probably I can give him the best chances of not resulting in some type of conviction on his record? So let's do that. Let's talk about that for one final moment. One, the concealed carry laws. What type of training can you give him? For the concealed carry type of training, you need to train him in the prohibited areas where he can't carry. He's got to know where he can't carry. Okay. Two, he's got to know about the drinking. The drinking and the gun, that can't match. He can't get the DUI with the drinking. He's got to know that he can't drink the drinking, the DUI laws and the drinking that are prohibited. He's got to know the prohibited areas. He's got to know that. More importantly than that, you've got to do the training on the mental the aspect of it. You've got to do the mental aspect on this, on making him a decent shooter, making him know a competent shooter. Making him know the fundamentals of the mental aspect of being a shooter. Making him know when he can pull that gun out. Making him know he can pull it out confidently. Making him know that it's a right time to pull it out. It's a right time that you know the definition now. You know the definition. Reasonable fear for death or great bodily harm to himself or others. Drill that into them. Whisper that in his ear as he's putting those bullets down range. Whisper that. Are you in fear for death or great bodily harm? As he's looking at that silhouette, whisper that into his ear. Death or great bodily harm. Make that stand. Put that in. Make them know that when they're doing that. And put that the standard when they're thinking about that. Let them know that the state's attorney's office, the prosecutors out there, they're not as sympathetic as you might think they are. Do you understand? I know they sound wonderful out there when they're prosecuting a case, but they could prosecute you just as easily. They're not afraid to prosecute you. So I want you to know what the law is. I want you to know that more than those 16 hours of training, give yourself the chance. You haven't been in that scenario. The paper targets are wonderful for training, but they don't shoot back. They don't run at you. They don't move side to side. Take the opportunity that advanced training will give you so you know how your mind will react when that scenario comes. So you will know how your body will react. So you can start to develop some of those muscle memory. So you can start to react. So you know how your brain will react. So you know that you can protect your family. Take advantage of some of the other classes. Take advantage of some of the other training. So your mind will know I'm reacting out of fear and training, knowing that I'm responding correctly, that I know that I'm a fear for death or great bodily harm for myself or others right now. That's what they need. That's what they need, more than just the cursory explanation. They need to have confidence in those skills. And I'm talking about somebody who's picking up a gun for the first time, and they're just reading their owner's manual for that Glock, and they're gonna pick up a striker fire weapon. They don't know the difference between a center fire or a striker fire. They're gonna pick up a striker fire Glock or Smith M&P. You see them all the time. You know what they're buying. That's what they're gonna pick up. And they just need to know the limitations on it. They need to know that maybe they don't need the 9mm. They don't need that much firepower. You're seeing the way they shoot. Are they holding groups on that Smith M&P? Maybe instead of buying the weapon the first time, maybe they need to go to a range and try a 380 caliber that feels better in their hands, that they're more confident with. Instead of buying the Glock 40 because it's a big gun.
That's something we started doing, is renting out some common firearm types.
Renting out smaller calibers. Man, that 380 might not be as big, but you shoot one hell of a group with that 380.
And that's important.
That's hugely important.
Yeah, shooting accurately is much more important than shooting quickly.
Or the bigger the hole you leave. Does that shoot accurate and lead and quick. Fast speed kills, you know that. Speed is your most important thing. Lead on target kills, stops the threat. That's what they need to train on. That's what they need to do. They need to be confident shooters.
And how often is something so vitally important so fun? Like, what other training out there is it like, oh, this is just so great, you
exactly.
know?
And that's exact. And the more you do it, the better you get at it. The smaller the groups get, which is nothing's more reward. It's nothing's more rewarding than seeing the groups get smaller and smaller.
Your ease of mind is just beyond comparable.
That's exactly correct. It's a fun hobby. It's a fun sport. It's a fun activity, and you get nothing but better at it the more you invest in yourself with it.
Truly empowers you.
It does. It does. And it empowers your family. It makes your family feel safer.
Yeah, not in an egotistical way, but in a true way. It gives you the ability to be self-reliant and the protector of your home.
Correct.
Well, I can't thank you enough. Remember, ladies and gentlemen, for all of you watching, if you have any questions or comments, or if we maybe didn't cover something, please feel free to reach out. Perhaps we'll have to do a part 2 series, because there's just so much to talk about when it comes to legislation and legalities, especially within the state of Illinois, as we've covered. We can avoid so many of these situations already as it is if we just come together and band together and stand up for one another. A woman being sexually assaulted on a train and nobody intervening at all is insane. We need to realize that we are all here. We all have a purpose for one another. We can provide safety. We can protect one another. We can stand up for each other and avoid these situations from escalating to a deadly means as it is. So if you have any questions or comments, or maybe we didn't cover something because there's so much to go into about legalities here, please reach out, shoot us some questions. Maybe we'll do a part 2 series perhaps. I would love to come back. I had a good time. Thanks everybody for your attention today. I hope I did help answer any questions. If you have any questions, and anybody has any questions, don't hesitate to reach out. I'd love to come back. I thoroughly enjoyed talking with you today. Yeah, this was great. I can't thank you enough, Dan. So thank you very much. My pleasure, buddy. All right, everybody, take care. Be kind to one another. Stay positive and love your life. Have a good evening.